Call to order, please. Okay. Ann, if Stan leaves, will we still have a quorum, the three of us? Okay, great. Okay, to continue on, do you want to give your presentation, Josh? Yeah, let's. How long is it?
Hours.
You know, depends how many questions you have.
Oh, got it. Got to be real short then, okay.
No questions.
I go with the hours approach.
Imagine them, or
Well, we're just trying to figure out how important it is, being that it's given by you.
yeah. Well, I think that goes without saying that you can. I sent it ahead of time, so I don't know what. I don't think anyone printed it out yet. Sorry. Well, I mean, I'm not casting blame. I'm just telling you what I did. Exactly. All right, so my task, as I understood it, is this working? Can you hear me? Okay. My task, as I understood it, was to describe, and all of you are veterans, so much of this will be retread for you, but was to describe kind of what happens to a case once it comes to our office. So this is most of these, what I'm talking about here are mostly the disciplinary proceedings. Obviously, we also handle citation appeals, but those are a different enough animal that it's not typically handled in the same way. And the sort of underlying motivation for this presentation is as part of your overall discussion for why do cases take so darn long. So this is neither not an excuse or justification, just an explanation as to what happens to a case when it comes to our office and the process that it goes through in order to reach an outcome one way or another. Okay?
Great.
So first thing just to mention, as you know, the board has its in-house counsel or agency counsel, DCA. Only the Attorney General's office is permitted to represent most state agencies, unless that state agency has its own representation statute, which is rare. But most state agencies have to be represented by the Attorney General's office for any outward-facing proceedings, whether it's judicial or administrative. Anywhere where there's going to be a representation made in a legal proceeding has to be done by the Attorney General's office. So just a quick thing of the mission statement of the Attorney General's office. And the thing I would mention here is just that when we get a case, because we are civil prosecutors and feel ourselves bound by the ethics that bind prosecutors, criminal and otherwise, we feel an independent obligation and have an independent legal obligation to assess that case for ourselves as prosecutors and not simply file whatever charges may have been recommended by the investigation. So we assess every case for whether it meets the burden of proof, whether we have a good faith basis for believing that we can meet the burden of proof for that particular kind of case. So for most accusation cases, that will be clear and convincing evidence to a reasonable certainty that we can demonstrate these violations of the Practice Act.
Is that done by your office or is it done locally at the county? Done.
When you say my office, that we are divided into, so the way our office is divided is into the various cities. We have Attorney General's offices in Oakland, San Francisco, Sacramento, LA, and San Diego, and a small presence in Fresno. So, and you'll see in a moment, I'm going to get to that on one of the slides, but cases are assigned by geographic proximity. And so one of the things we assess when a case first comes into our office is whether it's been directed to the correct office. And then within that office, the supervising DAG, someone like myself, who assigns the cases to DAGs, makes an initial assessment of viability, but it's ultimately the deputy that's going to be prosecuting the case that makes an assessment in consultation with their supervisor about whether a case can be filed or not.
Josh, you said it's mostly clear and convincing. When does it become a preponderance?
I'll show you in just a moment. I don't want to give away all of my slides ahead.
Okay.
You've been doing this.
I've been doing this, yeah.
Lippy really likes
Trying to be a
jump ahead.
lawyer, I
It's
guess.
kind of what he's known for. Is that another language? Does that mean jump ahead or? So the idea of licensing law is, sort of at least three parts. The main one is public protection. But what does public protection mean? Removing the bad apple, deterring bad conduct, and promoting public confidence in licensed professionals. And one of the premises of licensing law is that actual harm is not a prerequisite to licensing discipline. In other words, no one has to have been injured or die. The point is to try to nip that in the bud before that kind of injury is actually suffered. Well, it depends when you were born, really. So just to give you a breakdown of the clients that the licensing section within our office represents. Now, you may or may not know this, but our office is divided into numerous sections that all represent different state agency clients. And the licensing section represents most of the licensing boards and bureaus, mostly Department of Consumer Affairs, although we also represent the Commission on Teacher Credentialing and some others that are not in the Department of Consumer Affairs. About 60% of our clients are healthcare related and about 40% are not. And we have sort of the big five, the clients that give us the most cases, and pharmacy is one of those, along with contractors and registered nursing and BAR, the automotive repair, and the fifth one I think is LVN, but I'm not sure. So those are the ones that are our most numerous in terms of case volume. So this is sort of a graphic that shows everything
nice.
that happens in a case from when we receive it. And I apologize for the eye test that it represents. But it's useful, I think, to think about it in terms of three phases. Phase one being essentially the pre-filing, filing, and setting of the hearing phase. So all of the stuff that happens solely internal to our office. The phase two stuff, which is all of the preparation for hearing and getting ready for hearing and prepping witnesses and interacting with the other side. And the phase three, which is the actual trial or evidentiary hearing of the case. And we're going to talk a little bit about each of those phases. But it's useful, I think, to see all the different steps and all the different parts that have to go into preparation of a case all the way through trial. And I can talk about these individual bubbles a little bit, but I think what I'll do is just move forward. But the basic idea is we are sort of like civil DAs in the sense that like a DA receives an arrest report or other incident report from a criminal investigative agency, but the DA ultimately has the responsibility for deciding what charges will be brought, or if any, and how they will be brought, and how to word them. We similarly receive investigative reports from all of our client agencies, and we have the obligation to assess those, to charge, under the various practice acts. We represent something like 40 different client agencies. We have to be familiar enough with all of those client agencies to know their statutes, know their regulations, know prior interpretations of those statutes and regulations, decide what can be charged to that burden of proof, whatever it may be in that individual case, and then prepare the appropriate pleading. So that's all in the first three bubbles here, up to pleading. And then beyond that is when that brings the other side into the case. And quite often, up to that point, we only have a one-sided view of that case. Either the respondent didn't participate in the investigation or withheld documents from the investigation, or somehow that person's perspective was not understood for purposes of the investigation. So it does happen that even after filing a case, we get a very different understanding of the case. And on occasion, although this is very rare, an accusation or other pleading might be withdrawn or modified based on new information that's received only after the document is served. So the accusation really should be thought of, although I understand it has deleterious effects on someone's, employability immediately, the point of it is to give notice of charges that are being brought. The accusation is not itself a disciplinary action or a consequence. It's essentially an opening. These are it's allegations that are yet to be proven. Exactly.
And Josh, with the attorneys that actually are reviewing like the pharmacy cases, do they maintain specialty areas, or is it just the luck of the draw who you get?
It's a combination. Because we get so many cases from all of particularly our big 5 clients, everybody has to be able to do those clients. And then we tend to have more specialization for those cases, for those clients that send us far fewer cases, because there's no point in retraining, attorneys. But yes, we do have some specialization. Like I tend to do more of the pharmacy cases that come into the Bay Area than anybody else, but there are 3 or 4 other DAGs that tend to, gravitate. It's a combination of, what are our needs and who do we have available, but people are allowed to express preferences and people do develop some specialization. But it's not formal in any way. There's no certificate saying that you're a pharmacy specialist or anything. So any more questions or comments about this slide before I move on? Okay. So we're going to talk through each of these phases a little bit. So the first thing that happens when we get a file is it comes through the SDAGs, which are the supervising deputy attorneys general in each city. In every city except Oakland, there are multiple. There's just 1 in Oakland, but in every other city, there's 2 in San Francisco, there's 3 in Sacramento, there's 5 in LA, there's, I think, 4 or 5 in San Diego. And the SDAG does all the initial case receipt intake and review of the case. And the most important thing you first look at has it been sent to the right city? More often than you would think, things, we have a geographic map for assignment. It's not always clear where the cutoff line is particularly in the Central Valley from north to south, things like that. So we have to do that. We have to look, is it an expedited file for any reason? Has the agency requested an interim suspension order or an appearance under Penal Code Section 23? Is there a statute of limitations issue? Is there any other basis for expediting it? Is it, is there actual patient threat? Is there a patient harm, patient death? Things like that. One recommendation we make to all of our client agencies, and pharmacy already does this, is that if you ever have a reason for expediting a particular case, don't rely on putting that on the paperwork. Make sure that you email all of the SDAGs in that particular city to request an expedite on that particular case. And Susan and her staff already do that. Some of our client agencies, and this is not true of pharmacy, but some of our client agencies do have statute of limitations on their cases. In case you're not familiar, a statute of limitations is essentially a jurisdictional requirement that you file a case within a certain time period from, and it's worded differently for different agencies. Sometimes it's from date of the incident. Usually, if it's from date of the incident, there's a tolling or an extra provision that allows extra time from the date that it was reported to the agency, so that, if something is sealed for a long time, that doesn't prevent the agency from going after it. It's only from the time that they know about it. So there's no universal statute of limitations, but I would say that most of our agencies that have statute of limitations are somewhere between 5 and 10 years. So as long as the case is filed, and this is not completely prosecuted, but as long as the accusation or whatever the pleading might be, is filed within 5, 7, or 10 years of the incident, usually within 18 months of the reporting to the agency, that is sufficient for to get within the statute of limitations.
Do we have a statute of limitations for
Board of Pharmacy does not. In fact, we only have, I think, 3 or maybe 4 client agencies that do. CSLB has one, Dental Board has one, a couple others that I can't remember.
Medical board doesn't.
We don't represent medical boards, so I'm not as familiar with them. I'd hate to say, but I don't think so. So then we also at the SDAG level have to decide what matter type it is. Sometimes the client sends it over, not sure whether it should be an 820 evaluation, a psych eval, or an accusation, or both. Sometimes they're not clear whether it should be an accusation or a petition to revoke. If something happened while someone was on probation, but is not technically a violation of any of their probation terms, does that mean it should be an accusation or a petition to revoke? Those kinds of questions have to be initially sorted at the SDAG level in consultation with the client. Then once that's done, typically within 5 days, our goal is 10 days, but typically it's within 5 days, the SDAGs in that city meet to assign cases that have come in during that time, and they'll assign it to the deputy that's going to handle it. That case opening is then, so the whole time period for assignment and case opening is supposed to be no more than 15 days. 10 days to assign, 5 days for the paralegal to open and assign the case. And that's when you'll get the acknowledgement letter. The goal is within 15 days of receipt of the case. And I think our time periods on that have actually shrunk quite a bit, at least in the Bay Area recently, because we've changed our assignment protocols. So then it goes to the DAG, who looks at the case and decides whether everything they need is in the case. We've recently set a goal of the DAG doing that within 15 days, particularly for the purpose of deciding if any additional investigation is required. This is not typical of pharmacy cases, because pharmacy cases typically are fully investigated, but we have some clients that, particularly I'll just use Commission on Teacher Credentialing as an example. They have very strict timelines that affect how quickly they have to refer a case to our office, so they don't have time to pre-investigate it quite often, and they didn't previously have investigative staff. They're now ramping up with investigative staff now that they've come over to our section. So they were not able to pre-investigate cases as much, so it was quite often incumbent on us to come up with an investigative plan for them to investigate those cases. But most of our clients do pre-investigate cases, and they come to us with some kind of hopefully comprehensive investigation, but there's always follow-up that can be done. There's often documents that are missing. Just as an example, quite often we get a pharmacy case where someone has stolen drugs from a pharmacy. That has been reported to police. The inspector has made an initial request to the police agency for a disposition or maybe to the court for a disposition. It hasn't come in. The inspector feels, an obligation to move the case along, doesn't want to wait for that, so closes out his or her investigation, forwards the case to us, and then it becomes our obligation to follow up to see if that investigation resulted in criminal charges or not. So that can be a further investigation that either we ask the client agency to do or we do on our own, but that's one possible area of delay. So I'm just going to sort of, I'm not going to be, at the end I'll be a little more comprehensive, but along the way I'm just going to sort of mention little places where possible delays come in.
How does that impact your case? If, let's say, there is a criminal conviction.
Well, I mean, it's one thing to say that someone has stolen drugs with or without an admission. Maybe the theft allegation is based on a shortage that happens to coincide with that person's work hours.
Mm-hmm.
That's not that's not dispositive proof. Maybe you have them on video doing furtive things, but you can't exactly see what they're doing. If that person has then, either pleaded to or been convicted of a conviction that arises out of those same facts, obviously your case gets a lot stronger. It sort of depends on how much evidence you already have. Quite often, personally, I will advise that if we have enough evidence without the conviction, we should go ahead and plead the case and file it now, assuming workload permits that. And if the conviction comes in later, then we can amend. But it really depends, and that's where these kinds of delays get built in, because every case is so individual. There's no uniform approach to every one of these cases. You have to kind of assess each one, discuss it with your supervisor, and decide whether you're going to plead it now or later.
So you don't purposely, if there is a criminal case pending, you don't purposely wait for the outcome of that before you go ahead with yours?
Well, sometimes we do. And this is going to get into real legal arcana, so just hold on for a minute.
Okay.
There is a thing called collateral estoppel, which is a legal principle meaning that if we went forward with our case on the same facts as are at issue in the criminal case, and we lost, we might prevent the criminal case from going forward. Because we would have, we are the people, we are the state, we are essentially in privity with the DA, or that's questionable, but it's not clear that would be the case, but that's a risk. So, depending on the seriousness and the proximity of the criminal case, like how soon it's going to happen, we have to make an individual determination in each case. Do we want to wait for that criminal case? Does the criminal case seem like, the more important thing in this instance? So quite often we will trail the criminal case, and sometimes we'll sort of put the case on hold for a while to see if the criminal case is going to resolve quickly. And if it resolves quickly, then we'll wait for it. But if it seems to be dragging on, then we'll file our case. So there's no easy answer to that. But I would say the case I was talking about was, a case where a technician typically has stolen drugs, has repeatedly admitted that he or she stole drugs, in an interview and in a written statement. There doesn't seem to be any, evidence issue. In that case, I think we should go ahead and file, even if we don't have the conviction. But that's, that's an easy case anyway. The cases that are harder are cases where, there's allegations of Medi-Cal fraud, for instance. And we discover some of that ourselves, and we cross-refer the case to the Bureau of Medi-Cal Fraud and Elder Abuse. They commence an investigation. They want us to wait for them because their investigation is, more important in the theory and under the theory that they might discover much more widespread fraud than we have because they're going to go and audit, 3 years worth of. So that can lead to a lengthy delay and for legitimate reasons. Similarly, we quite often are co-investigating cases with federal agencies like DOJ or FBI. And we have one such case where we have multiple investigations that were waiting for a year or two the investigations were complete on our end, but the prosecution of those cases was waiting because the federal prosecutors kept telling us, we're going to file soon, we're going to file soon, we're going to file soon. They still haven't filed. So we've now decided, we have to go ahead with our case, but that built in a huge delay. So we are, to some extent, at the mercy of other investigative agencies sometimes. We can always choose to go forward, but it's a risky proposition sometimes to go forward. Because I'll just give you an example. What sometimes happens, and this happened in a criminal prosecution in a county that will remain nameless for the moment, is if we go forward first, even if it's on unrelated facts, let's say we carve out from our case a smaller subset of facts that are not so they intentionally don't overlap with the criminal case. We don't go after the main stuff because we don't want to possibly interfere with their, giving free discovery to the defense by having our hearing go first, or possibly collaterally stopping their case. So we do a smaller case. Then the defense goes into the criminal case and starts hollering about, the Board of Pharmacy looked at all this and didn't think it was a big deal. All they chose to focus on was this. So why are they making such a big deal out of this criminal? Why are they blowing this up into a criminal case? This isn't criminal. You should allow the administrative agency to deal with this. So, there's all kinds of factors that was what actually happened, and received a receptive ear from a particular judge who shall remain nameless in a particular superior court. So, these things might seem ludicrous under some circumstances, but they are considerations you have to take into account. So all of these things, are things that the DAG has to check for. Are there jurisdictional issues? Is there statute of limitations? Are there any other respondents that haven't been identified in this particular investigation? This happens a lot in pharmacy cases. There are often overlapping investigations that some respondents are the same and some are different, and you have to sort of parse out whether that's one accusation or multiple accusations. Pharmacy cases tend to be more complex than a lot of our other clients, at least the ones that are standard of care and involve a premises. Those tend to be much more complex than our other cases. So this is just more about what the DAG is looking for, whether there's critical documents or information missing. And then this is less applicable to pharmacy cases, but it does come up particularly in corresponding responsibility and other cases that are heavily about the judgment of a pharmacist. Most of the time, we rely just on board inspectors to provide the expert testimony we need about pharmacist practice, pharmacy practice, deviations from the standard of care. But if it's a specialty area, or if we just feel like we need bolstering to sort of more broadly, because our inspectors are often attacked as being insiders and having that biased perspective or whatever. So if we want to insulate the case from that, sometimes we will engage outside experts. So that can build in some additional delay in terms of getting that review, finding who we're going to engage, all that kind of stuff. So after the DAG has reviewed the case, there are essentially, 3 options. This happens very rarely, particularly with pharmacy cases, but sometimes we conclude that we just can't file the case as currently investigated. So we either request further investigation, or we actually decline to prosecute the case and say, if you want to come back to us with more investigation, you can. Those are sort of 2 ways of handling it. Most of the time, we give a heads up first to say we don't think we can prosecute this case. If it's clear that the case could never be prosecuted, even if you reinvestigated it, then we will probably just decline prosecution. But that, I can't remember that ever happening in a pharmacy case, at least under my watch. And then if we are able to, then the grumpy cat tells you that we go ahead and proceed to pleading preparation. So as you are all familiar, there are many types of pleadings. The most common that we are preparing essentially from scratch are accusations, petitions to revoke, and statements of issues. Accusations and petitions to revoke are affirmative pleadings filed to bring actions against an existing license. Statement of issues are essentially explanatory pleadings that explain the reasons for a denial that's already been made by board staff. So that's where an appeal is being made by an applicant to seek licensure. We do have sort of standardized formats as to how they should look, but there is room for individual variation both across cities and across individual DAGs. Everybody has a pleading style that they're slightly more comfortable with. Board staff are very accommodating of that within reason, but I often get emails or calls from Susan or others saying, like, is this one too far outside the norm? So there's a lot of that sort of individual variation. We are lawyers. We act like lawyers occasionally. We always think we know what's best. So, but we recently, as an SDAG group, just had a 3-day conference in San Diego with our supervisor to try to achieve greater uniformity in these. And so there will be less time spent, hopefully, on minor variations at the fringes of what the pleadings look like. I don't think that's ultimately that important, but it does, I think, help staff who are not lawyers when they can see the same thing over and over again and know whether it's a substantive difference or just a stylistic difference. And then just as a sort of general rule to let you know that our legal standard that we have to meet is what's called notice pleading. Notice pleading means you don't have to put all of the facts or all of the evidence into the accusation. It's like a criminal complaint in the sense that it just has to be enough to put you on notice of what statutes you are alleged to have violated and the basic facts that describe how you violated them. Sometimes that's all we do. Other times there are strategic or legal reasons that we might put more detail in. And without going into a lot of explanation, I'll just tell you that either of those can be a valid choice depending on the case. But that's also a kind of analysis that has to be done for strategic reasons by the attorney in deciding how to plead the case. And I mention that just to sort of emphasize that there is a certain amount of mechanical repetition in the pleading of cases, but there's also a lot of individual judgment and art in how cases are pleaded. You might decide ahead of time that this is a case you really think should settle, and in order to encourage settlement, you might plead it a certain way, either putting in fewer facts so that the person has less to object to, or putting in more facts to make the person aware that you already know everything and there's no point in fighting it. There's different strategic choices you might make, and different people feel differently about that. So it's not as simple as just pressing a button and pumping out a plea. Then there's a process that has to go through between our attorneys and staff where, and at the board level, there are three levels of review, really. There's an initial staff review. This is the board pharmacy. Then there's an inspector, the assigned inspector who did the investigation does a review. And then the supervising inspector that supervises that inspector does a review, just to make sure that everybody there, because we are just lawyers. We don't have the same level of expertise about the actual practice of pharmacy, about the drugs, about the pharmacology. So it's quite possible that we will misread something in an investigation report and either put in the wrong drug name or put in the wrong, indicator of why that was, contraindicator, something like that. So it really has to be reviewed just to conform with what their expectations were, having done the investigation, and their knowledge of what the violation should be and what the judgment should be that's implied. So that can lead to a process of amendment where the pleading could go back 2 or 3 times to the DAG for further amendments based on that review. Usually it's only one amendment, if any, but sometimes it can be multiple. Oh, no problem. I understand. Sure. Then we serve it. So all of this, all of that is supposed to happen within our internal deadline, or our internal goal is that that initial pleading should be sent to the agency within 90 days. That's 90 days from date of receipt. So that doesn't include the time that might add on to that for amendment, because we consider it, that completed once the initial pleading is sent, and then, some amendment might add that in. So that's the first 90 days of a case is supposed to lead to that initial pleading.
That's sent directly by your office, not the board.
Right. I'm saying this is the pre-filing version of it. So this is when we send it to board staff for review by board staff, the inspector, and the supervising inspector.
Accusation, okay.
Yeah, exactly. Whatever the
Got it.
pleading may be, accusation, petition for revocation, or statement of issues. So that time period for them to review it could be 60 to 90 days. So you're already at 180 days just to get the pleading done. Could be. I mean, that would not be unreasonable, is what I'm saying. If you think about, particularly in complicated cases, that's, I think, a fair, reasonable expectation that a pleading of a case from start to finish could take 120 to 180 days. But then after that's done, then it's served on the other side, and that kind of puts the case at issue. That's their first notice of it. Yeah, it's an alligator giving a legal summons, or a crocodile, I'm not sure. You can't see the tail, so I can't tell. And then that's when the clock starts for the other side. If it's an accusation or a petition to revoke, the other side has 15 days, technically, to return a notice of defense. If they don't, then the board can pursue a default. In actuality, more than 15 days is routinely given, both for, just workload reasons, but also for sort of due process reasons, because there's an age-old saying that the law abhors a default. Nobody wants a case to be decided by a non-response. So we typically try to give people more than what is the legal minimum. Sometimes we even follow up with them by phone. I mean, that's not our obligation, so we don't always do that. But if we have reason to think that they may not have gotten it, maybe we'll sometimes follow up. But if they don't file a notice of defense, then the board proceeds by default, which you're all familiar with because you all review them all. And that's essentially just saying that they failed to respond, so therefore the allegations in whatever the pleading was are assumed to be true on the evidence in the file. But if they do respond, they may identify counsel at that point. Typically, a lot of people respond initially without counsel, just to get in under the timeline. And then counsel will enter the case later. That is another place for additional delay, because you may have had an understanding with the respondent about, either a possible settlement or a timeline for setting hearing dates. And then when counsel comes in, that understanding might be renegotiate. Then we provide discovery, and we are like criminal prosecutors in this respect as well, in the sense that we have an affirmative discovery obligation. We typically turn over our entire investigative file to the respondent. They also have reciprocal discovery obligations that are less often met. So we don't often get a lot back from the other side, at least not timely. Quite often we're hit with discovery documents, right before hearing or at hearing, and our only, remedy at that point, the remedy should be exclusion of those documents, but not very many administrative law judges are going to be willing to exclude those documents. So quite often our remedy is to seek a continuance or do something if we really need time to prepare those documents. So, but the timeline for that is supposed to be 30 days to get discovery. I will tell you that 30 days is routinely extended. There's a sort of what you wish for and what you can get done. And one thing I just wanted to mention, I mentioned this earlier in the day, but I'll just repeat that the Attorney General's office is now catching up a little bit in terms of the staffing levels necessary to meet staffing levels that were given to agencies. So then you enter into settlement negotiations, which looks at things like, mitigation evidence, the strength of our evidence, whether that person has been through a diversion program, whether that person's willing to surrender, whether it's a probation case, whether there's cost recovery in the case. And as you know, cost recovery applies to both the investigative case, the costs incurred by the board. The board bills for its inspector time. It doesn't bill for staff time, typically. And also includes time for my office. My office bills at a pretty low rate for lawyers, but it's 170 hours for attorney hours, $170 per attorney hour, $120 per paralegal hour. So, for the Bay Area, that's, rarely low, but that's still in it, and it's all set. That's not a rate that's set according to market. It's a rate set that's according to recover the Attorney General's costs. Settlement is, and the reason board staff are so important in this is that settlements, the goal is to make those as consistent as possible with other settlements that have been offered or other decisions that have been issued by the board. And then, of course, we always have to consider the board perspective. Board membership changes, board expectations about what a case is worth change dramatically over time with those fluctuations in board members. So sometimes the staff are catching up. They may have had a more hardline board and they are still giving settlement offers that reflect that perspective, and then they start getting decisions, because the only way that the staff are educated on that is by decisions that are rejected or made by the board, and it takes a while to catch up on what the board's expectations are about what a certain kind of violation might be worth, unless the board takes it upon itself to revise the disciplinary guidelines, which is the other way that the board can more affirmatively set forth those expectations.
How do you get that information back, Josh?
Sorry, say it again?
How do you get that information back?
Well, I'm not sure what you mean. How do we know when a case...
Oh, okay, so the composition of the board changes,
Right.
and they've got a different operating philosophy. How do you find out what's gone through after you give it back to the board and it goes on?
Oh, well, if a case is let's say we send in a stipulation and the board rejects it, then it comes back to the same assigned DAG for further prosecution. So we know, I'll just give you an example. It wasn't this board, but I had a case where, we'd sent over a certain stipulation with all the terms that the agency staff recommends. Because remember, the whole point of this is, in order to maintain the due process rights of the accused, of the respondent, the board members have to be screened from any knowledge of the case until it actually comes before them.
Right.
So that sets up a slightly, complicated procedure where board staff are trying to anticipate what settlement terms will be acceptable to the board. And they have lots of guidance in that in the form of the disciplinary guidelines, but the disciplinary guidelines can be departed from in individual cases. So if the individual composition of a board chooses that in a particular case, then board staff have to decide, was that unique to that case, or do we see a trend developing here? And the same thing happens in our office. We typically depend on board staff because they see more of their own individual agencies' cases to know better than we would. But we also get that information. I recently had a case that went up before a different board where a particular term was stricken. The board said, we're not adopting this stipulation because of this particular term. We think that's too strenuous. So now we're going to be looking for that board, are we going to be putting that term in, or are we not going to be putting that term in because the board doesn't like that term anymore? But it takes a little while for a sufficient quantum of evidence to develop in order to adjust to the expectations of a board. And because of the ex parte communications limitations and the Open Meeting Act stuff, you can't really, it's really hard to give that information directly to staff because the board can only act as a unit. Individual board members' perspectives are not irrelevant, but they don't determine how the staff should respond. So the only way that the board can express that is by its common actions. And the way it does those common actions, you can make policy statements, but typically it's by making decisions. You have something you wanted to ask?
Yeah,
Amy?
no, I think that's a really good point. And also because of all the different DAGs across the state that are interacting with the office, the staff is really important
Right.
because they kind of keep the pulse on what the board's doing and can educate and say, oh, I think that's gonna fly or it's not because of this, because the board's leaning in that other direction.
Right, and I'm not saying that this applies to this particular board, but I know that, when cases are, say, held for closed session, and a vociferous debate about that case is shared with board staff, like the AEO or the EO attends or someone attends, it's really difficult, even if you observe that debate, to know whether there's just a particularly vocal minority that had a problem with that case. I mean, you can look at the end result, but maybe people were just swayed by a particular vocal minority in that particular case, or, were sort of deferring to someone else or whatever. It's hard to know if even that is a statement of board policy or just a one-off for that particular case. So it places board staff sometimes in a difficult position, particularly if the board is expressing a more lenient. If they're starting to go more lenient, it takes a while to adjust to that because that's not the expectation that the board staff have been given in the past. And that was not the sort of, there was a sort of general trend towards more stringent punishments under the CPEI. There was lots of requirements, particularly for those found to have engaged in substance use or abuse. Certain minimum, very onerous requirements were put in place. Individual boards were not given their usual discretion to accept or reject those. And so individual board members that are now participants in those boards may individually object to those. They may have limited power to deviate from them, at least at a policy level. You can do it in individual cases, but there's everyone's hands are tied to some extent. So this is sort of the settlement process. One thing that many of our clients have done, and that the Board of Pharmacy does to some extent, although I think it could do more, is to give us an upfront assessment of what staff thinks that case is worth in terms of settlement. It's a very difficult thing to do because for a number of reasons. One is, as I said, many times you only have a one-sided view of that case. So, the other thing is there's always incremental law and order creep in these situations, in the sense that you're always rewarded for being more harsh. You're never punished for that. The only thing that gets you in trouble typically is if you let someone go, as we just saw with Judge Persky, who was just recalled. The things that make a scandal and get you in trouble are when you choose to exercise your discretion towards leniency. So there's a built-in disincentive for staff to be lenient. Typically, it's only the final decision maker that feels comfortable doing that. So the terms that we get, I think staff only feel comfortable giving us upfront terms that are, surrender only or whatever, which I totally understand and I don't blame them for, but that's less useful. And then the third factor is, there's variation among the DAGs in terms of the trust level that staff have of are they just going to give that and just, or are they going to like give that as a last resort? You know, if I give them my real terms, the terms that I would actually be willing to settle back to too early, is the DAG just going to give up the farm and turn that over? Or could we get something better if we just, you know, start from a higher position? So I think all of those things lead to a tendency to give only maybe, I won't call them unrealistic, but I'll call them, you know, elevated expectation settlement terms at the outset of the case.
Which is such as the accusations all say to revoke the license.
I mean, I won't say that they all say that. We do get probation terms, but I would say that if anything,
of them.
they tend toward a higher level than the case typically usually ends up settling for.
Sense.
So those are all factors that go into it. As I said before, staff gives those terms to us. We negotiate those terms. Often they change from what was originally given to us based on, and as I mentioned earlier, sometimes that's based on new facts or new evidence that's produced by the other side that changes the view of the case. Sometimes it's just based on, you know, expense, time, workload, those kinds of things. And then that stipulation has to go to the board, and ultimately it's the board's decision. And it's difficult, even though we write settlement letters and so forth to explain cases to the board, it's difficult to convey without, you know, giving the entire case file in a letter all of those different factors that may have gone into a particular decision. And it may seem either unduly harsh or unduly lenient to you based on, you know, and sometimes this maybe some things shouldn't be recommended, but I'm just saying in general, at least the ones that I review, I feel like the recommendation is a good approximation of what the case is actually worth.
I see a lot in the mitigation area of this is the first time they've been brought up and so on. I don't usually give much weight to that because to me it means this is the first time they got caught.
Right. No, I understand that. And I mean, I think you're right that this being the first time is not particularly meaningful. I think what is meaningful is if this is not the first time.
Right.
So I think, you know, we could just leave out this is the first time from all of our letters where that's true and only put in, but I just think, you know, it's useful to know that, to have that confirmed if it is in fact their
Or
first
the
time.
other one is they've been practicing for a year and a half and they say this is the first
Right.
time.
Yeah,
You know.
I mean, you know, I don't control all of the deputies in the state, so I can't control what all of them do. If a deputy works on my team, I think if they've been practicing for a long time and this is their first time, that should be something you emphasize. If they've been practicing only for a short time and this is their first time, I don't think that's a big deal. That kind of thing. But this is where all the individual variations come in and how it's more art than science. So once you've gone through sort of that, typically we try first an initial settlement phase. We have so many cases and so much work that you have to settle a large majority of your cases. And because you know, there is a window of opportunity to settle a case at the outset before you even set it for hearing. We usually do that before we try to set it for hearing. And there's some sort of other logistical reasons that we do that. Because sometimes what I hear from people is, you should just set every case you get for hearing immediately as soon as you get it, or as soon as it's pled and a notice of defense comes in, because that keeps the pressure on and that, you know, that's more likely to lead to settlement even if settlement's in the offing. That's true sometimes and very untrue other times. Because what happens is, if we were to do that, if we were to set every case within, say, 15 days of a notice of defense, what would immediately happen is the Office of Administrative Hearings calendar would become clogged. So that every case would be set no more than 6 to 9 months, no earlier than 6 to 9 months out, and probably longer. Then that becomes a disincentive to settlement. If you have a hearing that's on calendar a year from now, especially if you're represented by an attorney, that's not even on that attorney's radar. They're not going to be interested in talking about settlement until you're within a month or two of that hearing. So setting a hearing in that case actually is a deterrent to settlement. So it's always we're always doing this dance where we try to do a little bit of settlement first. And a lot of defense attorneys, for reasons that are still unknown to me, see the setting of a hearing as kind of a failure. You know, if a hearing is set, then they've, you know, that's sort of an obstacle that's gotten over. So you can use that as kind of a carrot. You can say, either we settle this now or I'm going to have to set a hearing. And then that sometimes provides for movement. Then you set a hearing, and that's another phase you're in, and you're still trying to do settlement. But if you can't reach settlement, then you at least have a hearing date on calendar. But as this is where a lot of delays come in, is, as I mentioned earlier, you have to request a hearing date from OAH, from Office of Administrative Hearings. Their calendar is under their control, not ours. They have certain requirements that you can only set hearings within either 150 or 180 days, depending on which city you're in. So in other words, if I set a hearing today on June 7th, is let's say it's 180 days, that hearing can be no more than, it can't be any later than December 7th. But if you're working with opposing counsel, quite often they won't have a hearing date available within those 6 months. Or at least they will claim not to. And so let's say they give you dates in March. You can't actually request those dates from Office of Administrative Hearings under their guidelines. You have to wait and request them within that window. So these are things that, so there's two main things that affect our ability to more quickly set hearings, which is opposing counsel's calendar and the Office of Administrative Hearings calendar. And then, of course, our own calendars, although ours are typically more flexible than either of those. And then witness availability, obviously, we have to consider too. If we really have trouble with an opposing counsel, like there's certain opposing counsel that will not give you a date within a year. They just say, oh no, I couldn't possibly set this hearing less than a year out. That's obviously unacceptable for public protection reasons and other reasons. We will sometimes set a trial setting conference with the Office of Administrative Hearings, try to get them to hammer on opposing counsel to get them to give us earlier dates. Sometimes that's successful, sometimes it's not. It really depends on the sort of internal fortitude of the particular administrative law judge you have and how interested they are in getting the case moving. We don't have a ton of control over that, but we do try to get cases set more quickly than that.
How many cases do you typically settle in terms of percentage before they reach?
I don't know the actual statistics, but I would say in order to stay on top for a caseload, we have to settle at least 80% of our cases. I would say probably about 20% of our cases go to hearing, maybe less, 15, something like that. And that's across all matter types. So that includes citations, accusations, statements of issues, petitions to revoke, 820s, other things that we might file, ISOs. Okay, and then sometimes, although this is more rare than it used to be, sometimes the venue is a point of negotiation where the case will be heard. If a person is located remotely and all of the witnesses are located remotely, we might agree to schedule the hearing in a remote location. This used to be much more common when I first joined the office many years ago because the venue statute used to lean in favor of accommodating the respondent. Now the venue statute leans away from that. The venue statute requires that cases be heard in Office of Administrative Hearing offices, which are the same locations that I gave you for AG offices, essentially. The Bay Area just has one in Oakland, there's one in Sacramento, there's one in LA, and there's one in San Diego.
Was that a cost issue, or what is it?
It was at the time. It was during the budget. It was, I think, 2008 or something like that. They changed the venue statute to essentially say, we can no longer afford to pay for the time and travel to send judges elsewhere, so all the respondents have to come to us, unless there's some, extraordinary need shown. So very rarely now do we go out of office, at least in Northern California. I think Southern California does it a little bit more because Southern California is just so much more spread out. But, we don't do it as often. But that is another point of negotiation. Then you get the hearing date, you serve a notice of hearing. Sometimes that immediately prompts a request for continuance from the other side, because quite often you're required by OAH to meet and confer with the other side. This is what I was talking about in terms of requesting hearing dates from the other side. If it's an unrepresented person, quite often you can't reach them or they don't respond. So you just set a hearing date without their consultation. Then they get the notice of hearing. Then they say, I can't do that date, and they request a continuance, so that can lead to a further delay. Or, as I mentioned earlier, you get a date set with a respondent that's unrepresented. Then counsel comes into the case and says, I'm blocked on that date. They're not technically allowed to hire counsel that's already blocked on that date, so sometimes we object to continuance on that basis. But, you know, you want everybody to have their due process rights, so you don't really want to deny them their counsel of choice. So we are careful about how we do that. So if we think they're doing it just to manipulate the system, we will definitely oppose that continuance request. But typically, continuance requests are granted at least the first time, so that can lead to a further delay. Sometimes if it's a hearing of 4 days or more, there's an automatic pre-hearing and settlement conference that's set in so that the hearing will be set further out so that there'll be time to have that pre-hearing and settlement conference before it happens. Other times the parties can request that even if it's a shorter hearing, so that can build in additional time. And then there's all the trial preparation stuff that was on that slide earlier, which is gathering and organizing your evidence, making sure it's ready for putting in as a documentary exhibit, which is a different expectation than just reviewing it for pleading purposes, making sure you're up on all the law that might apply. There's a lot of time put into preparing witnesses, and what that means is meeting with them typically in person, sometimes by phone, in advance of the hearing to get them ready for their testimony. Not coaching them, but just letting them know what questions you're going to ask or what questions the other side might ask. And then, of course, preparing for the defenses, particularly if the defense has an expert. And most of the time we don't get defense expert reports. Sometimes we do, but often we don't. We just have a name and maybe a field of study. So we have to look that person up, figure out what they might be saying on the stand. A lot of it is just seat of your pants, being ready when they testify, because you often don't know what they're going to say in terms of the expert opinion they might render. You might have to gather some additional evidence yourself. You might need additional documents from a medical provider or someone else that you'd have to subpoena those. You might need to compel someone's attendance at a hearing if they're a reluctant witness. You might need to just give notice, like all of the board's inspectors for travel purposes and travel claim purposes need us to subpoena them even though they're friendly witnesses. Then any subpoena can lead to further proceedings because you might get a motion to quash that subpoena for records or for personal appearance. You might get a motion for a protective order to limit it. So those are all things that can lead to additional proceedings and additional delay. Then you have the actual hearing. This is another opportunity for a default if the respondent fails to show up. Sometimes we have the tricky question if the respondent doesn't show up, but the respondent's attorney shows up. Technically, that's a default. Do we proceed with a default? Again, the law abhors a default. Do you want to go for a default in that scenario? Sort of depends on the factual scenario. There's an ALJ there. There's documents and testimony. There's a record. The Board of Pharmacy cases are typically electronically recorded, which has upfront cost advantages, costs less. It has some backside problems in the sense that then you have to pay to have a record made, have someone listen to the recording and have a record made, which sometimes is more expensive than having an initial court reporter. But since so few cases have transcripts prepared, I do think that works out to be a good cost benefit for the board in terms of the amount expended for electronic reporting. But that has to be by consent. So that's another thing. You have to ask the other side, are they willing to consent to an electronic recording? Because otherwise they're entitled to a court reporter, and then a court reporter has to be ordered for the case. They're all just little complications that come in every case. One thing I didn't mention is, if the person is not English proficient, it's our obligation to make sure that they can fully participate in the hearing, so we have to arrange for interpreters for those hearings. So this is, to get to your question, this is the standard of proof. This is on an accusation, the burden is on the complainant. So when we go to these hearings, we are appearing before the board. We don't represent the board. We represent the complainant, which in your cases would be Ginny, the person in whose name the accusation is filed. And that generally is clear and convincing. So any license that's considered professional, and there's case law defining this, but basically for your purposes, a pharmacist license is professional. Pharmacy technician license could be treated as vocational. The difference between those is that for a professional license, the burden of proof is clear and convincing. The idea being that person is invested enough in that license that the property interest in that license is greater, and therefore the burden of proof that should be met to take disciplinary action against it is higher. So that's clear and convincing. For a pharmacy technician, because it's a vocational license, that could be proved by preponderance of the evidence. Typically, we treat all cases, initially at least, as if they have clear and convincing requirements just to be safe. But technically, we could proceed with only a preponderance of evidence on a pharmacy technician or any other kind of vocational license that's not deemed professional in the eyes of the law.
Does the same thing hold true for the pharmacy sites in terms of a pharmacy versus a wholesaler? Versus a clinic?
There's no clear law on that, so that's, speculation at this point.
Actually, excuse my interruption, but there is the board has taken the position that that is a non-professional license, and I use that recognizing that designation does not acknowledge that there's a certain respect due to the business, but it's the same way that we talk about licensed members versus professional members. It's a business license that's taken very seriously, but because it doesn't have the education and the investment factors that are associated with what's deemed under the law a professional license, the board's taken the position that that is an occupational license.
Right, and that's consistent with all.
She's talking about the technician, right?
No, she's talking about pharmacy
I'm
license.
talking about
any non. So basically, the only ones that are professional are those that are commensurate with a degree, typically,
Okay.
professional degree. So because a pharmacy license, although can be run by a pharmacist, doesn't have to be run by a pharmacist. So pharmacies and wholesalers are in the same category of a vocational license as opposed to a professional license.
Well, in that respect,
All I meant is there's no specific case law on that particular kind of license, but the case law that does exist strongly suggests that they would be treated that way, and on that basis, the board has made a policy decision that they will assume that's the case and assume that the preponderance of the evidence standard applies to accusations and other pleadings against pharmacies and wholesalers and so forth.
so what happens with a case where, if that's true, the degreed is different from the non-degreed licenses? What happens when there's a case where the PIC and the pharmacy are both involved? Are they treated the same, or is the pharmacist held to higher standard?
I mean, I will tell you what should happen. There should be a different standard of burden of proof applied to the different respondents in that case. As I mentioned before, what typically does happen, because most of our cases we have clear and convincing evidence anyway, the ALJ just does one recitation of the standard of proof and just
Right.
assumes that applies to everybody. That's been my experience. I don't know if
Yeah.
review
And
cases feel different. but-
There has been a writ on one of those cases, and at least through the Superior Court, we've been successful with that, drawing that distinction. So,
Right.
Thank you.
So then, all the only disciplinary actions against professional licenses have this higher clear and convincing evidence standard. Everything else is preponderance of the evidence. So basically the law says unless another burden of proof is specified, it's always preponderance of the evidence. So that applies to statements of issues. Statements of issues are, again, where an applicant has been denied. In a statement of issues case, that burden of proof is actually on the applicant. It's their burden, even though we're bringing the case, that's just for convenience sake. It's really their appeal that we are facilitating, and therefore they have the burden of proof by a preponderance of the evidence to show fitness for licensure and entitlement to licensure. For logistical and practical reasons, even though they have the burden of proof and would therefore arguably go first, because they're usually unsophisticated litigants, we go first in the presentation of evidence. Other cases that are also preponderance of evidence are citation cases, petitions to revoke probation because you've already been placed on probation, so it's an administrative case, it's not an underlying disciplinary case. Interim suspension orders, 820s, things like that would all be preponderance of the evidence. So these are some of the issues that can arise once you have a hearing set or in preparation for hearing. There are often either formal or informal motions in limine, and motions in limine just means basically limiting the evidence. So you might decide that, you might know that someone has let's say you have a pharmacy case and they've identified on the other side an expert who's a contractor. And you're like, what could a contractor possibly have to contribute to this case? You might file a motion in limine in advance of that case saying that person should be excluded from testifying. I don't want to waste my time, having to cross-examine that person, having them have to be excluded after the case. I'd rather save the time of the court and my own time by having them excluded ahead of time, something like that. Other times you might stipulate to either part or all of the facts of the case. These are all pre-hearing negotiation kinds of things where you might want to, quite often in our cases, or not, I would say a small minority, but still seems fairly frequent, the defendant or the respondent will just say, I admit everything in there, but I'm a different person since then. So then it's what we call a mitigation case, where we just go in and say the facts are stipulated, and then they get to testify about, how they have changed. There are lots of issues about discovery and evidentiary rulings. As I mentioned, we have lots of issues with whether we timely get discovery from the other side. We try various gambits to force discovery from them. We file preclusive motions, things like that. Sometimes we're successful, more often we're not. But often we're blindsided with discovery right before the hearing or on the day of the hearing that changes the outlook of the case. We seek evidentiary rulings to try to exclude that evidence or whatever. So then there's, we have to develop impeachment and bias evidence. If we learn, that, like for instance, that an expert is being paid an extraordinary amount of money for testifying in that case, you have to ask, why is this expert so expensive, and what is the respondent buying with that testimony, with that amount of money? So anyway, all these kinds of things are things you think about in preparing for and following through with a hearing. Then there is the part that happens after the hearing, and you guys are familiar with this because this is where you are most involved. This is dealing with a contested hearing. This is not settlement, but if you replace ALJ issues proposed decision with stipulation sent to board, it's essentially the same flow chart. That goes to the board. The board obviously has the final decision on whether to adopt or non-adopt that decision. If they adopt it, they don't have to adopt it entirely. They can adopt it in its entirety. They can reduce the penalty. You can't increase the penalty by adoption, but you can reduce it. And you can also make some minor changes in it if the license number has the wrong digit, or if the expiration date is wrong, or some other minor thing that wouldn't change the substance of the case is wrong. The board can just correct that without having to send it back to the ALJ. If they want to send it back to the ALJ, or if they otherwise want to reject it, then they issue a non-adoption or a rejection letter or notice, and then they can either send it back to the ALJ, or they can order the transcript and write their own decision. Pretty rare to send it back to the ALJ, but sometimes a particular issue might be unclear and you just want further evidence on it, so that might be a reason to send it back. Or sometimes there's a substantive flaw in the decision. This happens more often than we would like, where an ALJ just gets the disciplinary guideline language wrong in some way that's actually substantive and requires correction. So those are sent back on occasion. Once the proposed decision is issued, it's supposed to be issued within 30 days of submission of the hearing. That's another possible area of delay. Submission of the hearing can be delayed. You can actually put in all the evidence, but then the ALJ might say, I want written closing arguments, and I'm going to give you 30 to 60 days to send those in. And so that delays submission of the case until written closing arguments are received. And or sometimes the ALJ will say, the respondent will say, oh, I forgot some documents. Can I still send those in? And the ALJ will say, yeah, I'll give you 30 to 60 days to send those documents in. Then I'll give the Attorney General's office another 15 days to respond to those documents if necessary. And then I'll deem the case submitted. So that could delay it by 60 to 90 days. We actually have now a milestone event in our case management software for hearing submission delayed because it happens so often. So the 30-day clock doesn't even start until the hearing is submitted. And then even if that 30 days is not met, there's no real consequence. Like the board doesn't lose jurisdiction or anything if the ALJ doesn't meet that clock. It's really more of a guideline. I think most ALJs do meet that guideline. I don't know. The board could tell you, the staff could tell you better than I can because I don't see it at that level. But my impression is that they do. Once you have gotten the decision, you have 100 days from receipt of that proposed decision from the ALJ to do something with it. If you don't do anything within 100 days, it's deemed adopted. So if you want to non-adopt it, you have to do it within 100 days. Now that 100 days can be extended if you order the transcripts, and then it's 100 days from receipt of the transcripts. But just keep that 100 days in mind. Then there's all kinds of other things that can happen after the hearing if the respondent petitions for reconsideration. Then there's a final decision, and we close our case. But quite often the case, I would say less than 10% of the time, there's a petition for writ of administrative mandamus filed in Superior Court. That is the means by which a respondent can appeal an adverse decision. There is no direct appeal. It's essentially by a writ, which is meant to be an extraordinary remedy, but it's become more routine because there is a statutory remedy for it. Do you have any questions? I wasn't planning to go into writs in any detail, but if you have more questions about them, I can. Okay. Yeah, I'm sure you're tired at this point. All right, so here's where I've sort of summed up all of the things I've talked about along the way of the greatest contributors to case delay, and I divided it up into various stages. At the investigative stage, as I mentioned, quite often there's criminal cases or other co-investigations that we might be waiting for, or that might be asking us to wait, or that we might be working in concert with. That can lead to significant delay at the investigative stage. Quite often, and this is more common with pharmacy than with other client agencies, additional complaints come in or additional investigations are prompted by something or other. And so we get supplemental investigations, or we hear from board staff, don't plead that case yet. We are doing another investigation, and we want to wrap it all up in one. So that can delay the case. And it's really tough. I understand the dilemma that enforcement staff and executive staff find themselves in. You never know when is enough. You never know when your case is already strong enough that you don't need further investigation. You don't want to leave a complaint uninvestigated. And you also don't want to, foolishly expend resources by going after somebody based on a weaker case when you could wait and have a stronger case. So it's really tough to know when to cut it off, when to not send over supplemental investigations, or when to not investigate something that comes in. But it's also very difficult for us on our end to be receiving, supplemental investigations in a case that we thought we knew what it was about. Because it's not, then you have to go back and refamiliarize yourself with everything that you've already read once you get the supplemental investigation, because there's typically some time period in between. So it's just, it's just hard to deal with at both ends. Then at the pleading stage, as I mentioned, pharmacy cases, particularly involving premises, are typically more complex. Compounding cases are very complex. It's a, as you know, specialized area of law. And so there's a certain psychological aspect of, if you have, most of our deputies are carrying 50 to 80 cases at a time. And if you have, 40 cases that are easier and 3 cases that are harder, which ones you're going to constantly think to yourself, I'm just going to clear my desk. I'm just going to get the easy ones done, just so I'll have more brain space to give to the hard ones. And then, you never get that time because more easy ones come in, or, whatever. So I would say there's some amount of delay built in because harder cases don't prompt faster action.
Well, it sounds like we're not going to be very successful in significantly reducing the time that's involved. So if we're really concerned about getting people, the consumer's safety, we're going to have to use a lot more of the suspension orders or whatever you call them to get them to stop practicing.
Right. I mean, I will tell you that as a supervisor, we dread getting requests for ISOs because the thing about an ISO is you can't just do the ISO. The statute requires that the ISO be immediately followed by an accusation. So you have to be ready to file the accusation when you file the ISO. So that means that case essentially has to go to the top of the pile, but it doesn't make the case any easier to prepare. So you have to do the same difficulty of case in a much shorter window of time than you would otherwise have to do it. It would be really nice if we had the ability to just get injunctive relief of some kind without having to immediately follow with an accusation, on a sort of preliminary basis. But we don't really have that ability.
That take legislation to be
Yeah,
able,
that would take legislation to be able to do that.
maybe we should look at that.
Yeah. Because it's really hard to take a case that would normally take, 120 days or more to really understand it and plead it and get it in a good condition, and have to do it within 15 days or whatever. That's really difficult to manage as a manager. So I guess what I'm saying is I'm not encouraging a huge influx of additional ISO petitions, because I understand the reasons that you would want them,
Right.
but it really upsets our workflow and it's
How
difficult
about
to
if we
manage.
can get legislation to take
Yeah.
that requirement out?
Yeah.
That would be the way to do it.
Anyway, so you get an idea. Then there's the settlement stage. Takes a really long time, most of the time, for opposing counsel to get us the mitigation. Like, they're not willing to settle for the terms we offer them because they say, you don't understand this case. This case is different than you think it is. Well,
Sure.
give me the evidence that it's different. 6 months later. You haven't given me that evidence that it's different. Okay, we're setting a hearing. Oh, here's all that evidence. Oh, well, that changes my perspective on the case. It's just, you're working with people that are motivated by different motivations than you are. Hearing stage, as I mentioned, all the calendaring and continuances that can happen, witness availability, and then all the delays that can be built in at the decision stage by the board non-adopting and taking longer to decide the case, either on its own or by sending it back to an ALJ. So all of those things, I don't have the actual stats here, so I'm not going to pretend to, but we do have stats available that could be presented to the board or to this committee at a different phase. But I can say without much fear of contradiction that it's, on average, it takes more than a year for a case to work its way, a pharmacy case to work its way through our office.
540 days you were talking?
No, the 540 is supposed to be from date of receipt by the agency so if we're taking more than a year of that time, that leaves less than 180 days for the agency to do its work. If you're trying to get the whole thing done in 540 days.
So the 1 year is if all stars are aligned here, or is this just the average?
Well, that's on average. I mean, obviously some cases are much quicker because they're a simple conviction case. And
So if all stars are aligned, what's the quickest it can go?
well, I hesitate. I'm not really authorized to give that number because I don't really, I mean, just because we haven't had the staffing levels yet
Yeah.
to really give you an adequate answer to that. I will tell you that historical data suggests that all stars being aligned, it's hard for us to get it under a year. It may be that we'll be able to get it down to something under a year, once we're fully staffed and, we've implemented lots of different new protocols to try to get it down further. But I don't want to I'd rather underpromise than overpromise. And so I think a year is a good average at this point.
So as a board member, if we're protecting the public and we know that it's taking 3 or 4 years to get these cases through, and in the interim, there's practitioners that are practicing, it puts us in a difficult position to protect the public.
I understand that. And I don't think there's going to be a great answer to that. I mean, the only possible answer is to do something along the lines of what Greg suggested, which is a preliminary injunctive relief that doesn't include, but that's going to raise a hell of a objection from the defense bar, because they're going to say, wait a minute, you can put me out of work and there's no time limit on how long you can put me out of work. You can just delay, filing the case. So I find that unlikely that would pass through the current legislature. I don't know.
Or even the ISO.
Right, the ISO, but the ISO, as I said, has those strict time limits when you have to file a succeeding accusation. So you could do a sort of minimalist accusation and plan to amend it later, but then you're sort of like, then are you really giving the person notice of everything that you have on them, or are you holding your cards close? Then it's become sort of a fairness issue. Like, are you just sort of doing the minimum in order to meet the statutory time limits, and then you're not really giving them a full chance to defend themselves? So it's a very delicate balancing act.
So on the other side of that is we can't really, because the delays, the public protection factors there, but then we also end up really, because it's gone so long, you're punishing someone rather than protecting the public. And that's something that you kind of run into as well, because 4 or 5 years goes by, people have changed and...
Well, I think you have to think of the protection of the public being less about that individual and more about the education of the industry writ large. Because you're right that typically that delay actually accrues to the benefit of the individual respondent because they've had those 3 years or 2 years or whatever it is to do good stuff, to show themselves to be rehabilitated or to, do community service or whatever it might be. So I don't think typically the delay doesn't harm them. If it harms anybody, then I guess you could say it's allowing a, potentially dangerous respondent to continue practicing during the interim.
Right.
But for those people that we think are really dangerous, I think we do, do an ISO or whatever. So then you are finding yourself in the position of dealing with cases where someone has done some bad stuff, but not immediately dangerous stuff that they did 3 years ago. What do you do about that? Well, I think you are putting yourself in the shoes of when they did it. They did it 3 years ago, and that is what you're giving the disciplinary penalty for. You are then also taking into account how they've rehabilitated themselves since then. So I don't think the passage of time itself should deter you from giving that person the disciplinary penalty that's appropriate to their conduct, because that is appropriate for their conduct under your own disciplinary guidelines, and it also has all those effects that we talked about earlier of deterrent effect on others, education of the industry about what the expectations of the board are, those kinds of things. So I totally hear what you're saying about the seeming unfairness of, administering a penalty 3 or more years after the acts upon which it's based. But I will tell you that under the law, there is absolutely nothing wrong with that. If there were a statute of limitations, that would almost surely be within the statute of limitations. And in the absence of a statute of limitations, the only outside limit on disciplinary actions is a doctrine called latches, which means, and the respondent would have to show two things in order to be successful in saying that latches applies. One, a substantial impairment of the case in some way. Witnesses have forgotten things or documents have been lost, and two, that impairment of the case accrues to the respondent's prejudice. In other words, that it harms their defense in some way. That's almost impossible to show in almost every case because we've collected all the documents that are relevant at the time. The case is fully investigated. They had the opportunity to participate in the investigation and to give their side of the story. I understand all of what you're saying, but there's a certain reality that accrues that it's not possible to do cases. If you want to offer due process protections and give everybody a chance to defend themselves and screen the board from being participants in it and give all of those kinds of due process protections, it's really difficult to do that quickly.
How long does the ISO typically take to get one?
Well, I mean, there's no requirement that we file it within a certain amount of time. There's limits that apply once the hearing is held, that it has to be issued within 15 days. So if we get it, we try. I mean, it varies across offices. So I think board staff can better advise you about how long it takes. And LA has, as I said, been understaffed, so has been less able to do ISOs. But, ideally, in an ideal world, we try to file ISOs within 15 days, and then they have to be issued within 15 days. So we try to get an ISO within a month, within 30 days.
Okay, thank you.
And you listed three things that kind of looked at the delay through rose-colored glasses, one of which was rehab, and then you said education of the industry, and then what was the other one you said?
A deterrent effect. I mean, those you can combine those two, I guess. But I think deterrent effect really refers to those people who might be doing the same thing and know that they're doing something wrong, but think that they won't get caught. This might show them that they could get caught for it. Education is really just to tell people that this is something that is wrong in case you weren't aware of that.
Okay. Well, see, I disagree with you on the last two because nobody knows what's happened. And so I'd agree with you if we made those results, put them in the script or something like that so people would know what happened. We've increased the explanations in the script of what people have had revocations and things for. But if we could make that more present in people's minds, some good might come of it.
I'm not sure. I mean, you mean
no,
because they are published in the script? Do you mean like make them more published than that, more publicized than that? Is that what you mean?
They're not clear enough, and people don't
Okay.
know that they're happening. So
Okay.
yeah, so yes,
It would have to be more detail in the script, is what you're
Yeah,
saying.
yeah, more juice.
Yeah, yeah.
So
Yeah, I mean, that's obviously a sort of publication decision that's beyond my purview. but I hear what you're saying,
right.
yeah.
But okay.
You made a comment also that we have to consider also we consider the rehabilitation efforts. Is that brought in? Is there attempts to bring that into the settlement discussion?
Oh, definitely.
If it
When I
happens
say
3 or 4
mitigation, that's
years?
what I mean. Is,
Okay, got it.
You know, if it's a substance abuse case, the first thing you're going to ask is, you know, has the person been through treatment already? Have they, you know, those kinds of things. What letters of what employment evaluations do they have? What letters of reference do they have? All those kinds of things are going to be part of the standard package of documents that you would hope to receive. You know, what community service have they done? Are they involved in their church? You know, all those kinds of things. You know, I don't think I need to tell you what
Right.
kinds of things we would look at.
Good.
Have they stayed on the straight and narrow? I mean, literally, I think, you know, it's rare. I mean, obviously, a passage of time could lead to more opportunity for that person to reoffend. So in that sense, it wouldn't accrue to their benefit. But aside from that, almost always the passage of time accrues to the benefit of the respondent.
And that could balance the delay, though, because if you know about that, you can consider that when you look at the final decision.
Right.
Or not.
Yeah.
Good.
We should. We
Yeah.
should, and I think we're remiss in that.
Any other questions or comments for me? Because that's the end of my presentation.
Well, I think your hope for applause is.
Well, I had one question. Now, citation and fines that
I didn't
come
put
in
that
there.
slide in. I'll be honest with you.
So the cite and fines that happen along the way, how are those considered when the accusation comes up?
So, as you know, cite and fines are not disciplinary. So they are not prior discipline, but they are a prior administrative sanction. So we do typically list them in the accusation as a disciplinary consideration. I would say that they're given about as much weight as you might expect, which is we all know that a citation can result from a very minor offense, or it could be a borderline thing that could have been an accusation but was treated as a citation. So I think they're noted, but they're not. No evidence is typically introduced as to them. No particular analysis is done as to them. They're just sort of like as Greg was saying, is this someone who's had any issues before? This is a non-disciplinary issue. So I think that's the best way to assess it, is that it has a small marginal effect.
And
So that's why licensees tend to try to appeal those citations, even though they're not disciplined, because it could appear on a record for future action.
I don't know why licensees. I mean, my experience has been that appeals of citations are typically an issue of personal pride more than an issue of their disciplinary record with the board. But, you know, I'm sure all kinds of motivations go into it, and that being a part of it. I will tell you that this board doesn't do something that other boards do. For instance, the Contractor State License Board, their citations go on their website, which I think actually
About that.
there's advantages and disadvantages to that. Obviously, that makes it a lot harder to settle them because, you know, particularly as a contractor where people are typically going to look up your license before they hire you. If you have a citation on there, you know, that can deter business. So there's a lot less incentive to settle a citation, given that even a settled citation is going to show on your license history.
So we're the only board that doesn't do that?
No, you're not. But I think CSLB might be I don't know. Laura might know better, but
It's an agenda item,
yeah,
that's right.
it's the minority that does put them up, I believe. The majority do not put them on the website.
I think it depends. It looks like the majority of healing arts do. We have the survey results.
Oh, okay. Well, then I'm wrong.
What?
Things have changed and no one told me. It
Right,
didn't used to
and-
be the case.
Josh, this was very helpful. I really appreciate.
It's really
I think all of
depressing.
us
Thank
do. I
you.
really appreciate all the time you put into this and the explanation. Very enlightening. Thank you.
I hope
Yeah,
it
yeah.
was not coma-inducing, but, you know.
Well, no, I'm still awake. I think most of the audience is. Thank you, Josh.
Thank
Yeah,
you.
We really appreciate that.
Give her an applause.
Oh, yeah, there we go. There we go.
He deserves that.
We've got a number of things to discuss. I'm going to go out of order again, and we're going to call the meeting at 4 o'clock, and we're going to schedule another meeting. We'll lose a quorum at 4 o'clock, and so there's no sense in going on. So we're going to discuss number 8, the discussion and consideration of implementation strategies for anticipated statutory changes to incorporate the USP compounding chapters. There's a variety of problems out there. There's a shortage of equipment. There's confusion about the chapters themselves, about how we're going to be regulating them, and so we want to get your concerns. We're going to talk a bit about what we're going to do. We want to open this discussion, and it's going to be an ongoing discussion, and it's going to be discussed at every meeting. We got to have some clarity around this. It's bad for the profession. It's bad for the public. It's expensive. It's going to increase the cost of treatments. It's vitally important for a number of reasons that we're all aware of, and so.
Alan, I guess I had a question on this agenda item. My understanding is that we've got a December 19 date that USP 800 is going to be essentially required. I mean, the board's going to
Right.
enforce it. So I think the concerns that I've been hearing is what's going to happen in December 2019 if the construction isn't done, and maybe how many pharmacies are actually in that area, in that challenge. Maybe we could hear from them as well. No, I mean now, if there's anyone here
anything now,
that
because-
finds that December 2019, whether there are concerns with implementation by that date, because that would really impact patients and access to care.
I believe we have about 400 waivers out there in
Well,
place.
okay.
So from CPHA's, I don't have specific pharmacies that are in this situation. However, kind of related to this, I've heard from several pharmacies now that they're not exactly sure what the board is looking for in terms of compliance specifically with 800 by the time December 1st comes around, because of the uncertainty of whether they're going to be punished or what. And so one of the things that I'm trying to work on right now is to see if there's a checklist to at least have some basics down for 800 that I can then turn around in an email or some sort of communication to our members and say, at the very basic level, this needs to be checked off. And so that's kind of what I'm working on right now, and it's taken a little bit of time to get all that information. But I think it would be helpful for the committee to at least discuss, is there some sort of list that exists, either from your side or from another side, of what is expected of pharmacists? Because again, for those who haven't, I don't know who has or hasn't received a waiver from you on any of this stuff, but I know that there's confusion, at least in from our association members on compounding, about what exactly that you guys are looking for in terms of compliance.
So we have current law, right?
Right.
There's current law.
Right.
So they probably need to comply with that,
Right.
definitely. But I know we've talked about adopting 797 and 800, but my understanding, is that legislative? Or can we do that?
That has to, well, we're going to go with a legislative solution. Like, we may be able to do it with regs, but it's actually faster to get a statute.
So that would be, what's the timing of that?
Well, the statute we would pursue next year because we're not ready yet. We don't know what we're buying with 797 yet, for example. They haven't issued the final form of that.
So right now, then, in answer to Danny's questions, wouldn't it just be the current law that's in
Yeah,
place?
there are 3 provisions in our current regulations that have 800 provisions in them. And those provisions require specific types of exhaust venting. And basically, what the waivers are is to provide time for people to do the build-out required, because constructing an exhaust vent outside of a room requires construction. And in some facilities, it's a big deal. In others, it isn't. If you are in a hospital, for example, you've got a couple of other agencies besides the Board of Pharmacy that are going to become involved in the review. If you are just a community pharmacy doing regular compounding but need to vent in order to comply with the requirements in 1735, then you're going to have to do some exhaust venting too. And so some of those entities were given waivers as well. So it
Okay.
wasn't just sterile compounders.
Right. And
Some of them are out
yeah.
of state too.
Right.
We've also-
Danny, is there concern from pharmacies that that are in waiver right now, that they won't meet the December 19 timeline?
No, the majority, well, I don't know. Let me answer directly that I don't know. What I've heard, people call me directly, they're just confused as to what exactly the board is looking for in terms of they want to be compliant, right? They're not sitting there going, well, this is wrong, or they just want to be compliant. And I think that's the main crux of the confusion that I'm getting from a lot of our members. And so obviously it would be easier for me to just say, here's a list, here you go.
Possibly, and I think the confusion may just lie from the fact that at this last meeting, we said we were going to look at 797 and 800. And
Yeah.
that's why I asked Jenny that question,
Yeah.
because I don't think it's going to be immediate. If it's a legislative solution, it's going to be after
Right,
next
and-
year.
and-
So the answer would be they'd have to just rely on the current law.
Okay, and
until-
that's really more what I was looking for, is kind of like a direct answer. If nothing else, in worst case scenario, whatever's currently in regs or in statute is something that I can point him to. And we, like I said, we're preparing a mass communication to go out to all of our compounders on this. So that's really helpful. The other thing, obviously, was the timeline, which you've already asked. Given that 795 and 797 are still in that process, again, the question is, because of that timeline, what is the timeline that they're expected to follow as compounders? And I guess from what I'm hearing from 800 is that if whatever's in current law right now, that's what you should be following. And then,
Unless they're under joint commission or other
Right.
accreditation, then they would probably be held to the standard of 800 just by nature of their license.
right, and just so people are aware, because I know this is being webcast, we are also going to send out a communication on, because I believe 787's public comment period is open, and I believe that closes July 31st. So we'll be sending communication out to our members that,
795.
795.
or 795, sorry. It's been a long day.
That one has some significant changes.
Yeah, and
On
so.
795.
And then lastly, I guess there's been questions within our compounding community of whether the board really has a desire to, in figuring out what's in conflict with USP and what is currently, aligned with USP. Is there a desire to more fix what's not in compliant, or to just scrap all the regulations, start with USP, and then build your additional regulations based off of that?
I don't think we can answer that until we see 797 and 795 in their final forms. And we
Okay.
won't even see the draft of where they're going with 797 until
Later this year,
another
yeah.
month. Well,
Yeah.
it's the end of July.
I don't think that discussion's yet taken place.
Yeah.
Okay.
And that's going to take a little while for us to do it, because we need to look at it and then compare side by side.
Well, and I figured I'd just let you know that that's the big surrounding questions that I'm not able to answer to our members yet, but that's good to know that at least I'm getting, at least
Encourage your members to participate in the discussions.
Yes.
Because they'll take place at this committee meeting, so that their regs are as clean as possible.
yes, absolutely.
Right, and if you could, since you represent so many members, if you send us your communique so that we can see what's gone out there, we'd appreciate that.
Yeah, absolutely. Okay, thank you.
Be great. Thanks, Danny.
Good afternoon.
Good afternoon, Jenny Partridge, 3 comments. Of all the pharmacies that I see, now keep in mind I hang out in the compounding world, so sterile and non-sterile. And I'm not seeing anybody in the independent retail compounding world that is not compliant with the venting at this point. And or no one is, I don't hear any concerns that people won't be compliant by December 2019. Because keep in mind, the original waivers, we were told were not going to go past July 1, 2018. So people kind of knew that, and most people have done the construction they need. And then when...
So they can thank us for that deadline.
Absolutely.
Yes, yeah.
And then the other thing they can thank you for is that you approved the redundant filters for the non-sterile. That made a big difference for people with the venting issue. So those 2 things are good. So that was the comment there. The other comment is just kind of to be consistent that we know that USP compounding chapters 795, 797, 800 all go into effect December 1, 2019. So we know that we're going to have the information on what those are going to be, certainly by the end of this year. So that gives us a year to figure out what California wants to do. So I think, again, we've got, we like Ginny and Amy were saying, we need to wait until the USP comments come back. I've certainly been involved in committees that are giving comments. USP 795 has some wildly rigorous changes.
Do we know, Jenny, when 797 is going to be final? Has there been any dates thrown?
Their goal, the first release of 797, I believe they're going to give a pre-release view on, I think it's July 27th.
July 25th or 27th.
Of this year. July 27 this year, and then for a few more comments, and then I believe do you know what the final is?
So it'll be publicly, so there's the pre-posting July 27th, and then the formal publishing will be September 4th. They're having an open microphone on September 5th, and then the public comment will close on November 20th.
So,
2018.
My birthday.
Happy birthday. You're getting a gift from
that's a big
USP.
happy birthday gift. So I was just going to comment and say, what I've seen other states do that have chosen to adopt USP compounding chapters, but they still want to have some of their own more rigorous standards. What they've done is they've taken USP as a whole and adopted that, and then in there, like our 1751, we would keep certain 1751s. But right now, because I frequently have to do this as a consultant, I have to marry our California regulations with USP, because there's a number of organizations that want to be accredited, but they are in California. And so, it took me quite some time, but I have some dandy gap analysis and grids. But there's some things that are just, it would be really difficult. To your point, Amy, it's complicated, and it's going to be much easier and I think safer, to your point, to have a baseline of USP and then have some additional California regs, which means, and I think, Laura, you talked about this at one of the meetings, we would have to repeal the 1751 and then add into that, correct?
It's impossible to know until we know what's in, but yes.
Right, so.
Right, once we understand that
Extent that USP would be setting the floor. If you adopt a statute that requires USP, then that sets the absolute bottom of the floor. Any existing regulations that go above and beyond that would still be valid.
I feel like this, I don't know if we need to say this now, maybe we can wait till later, but I feel like I should just reiterate that my experience with prior versions of USP materials is that they are not written in a manner that provides for easy enforcement. And they're not meant to be used in the way that states are now using them to set standards for performance standards. They are meant as industry guidance on best practices, which is different than a minimum standard. And so I hope that the new versions will be different and that it'll be easier to just adopt them as a minimum standard and then enhance them where they might need to be. But I suspect, given how these things are written, that it will not be written that way.
I agree with you, Josh, and I think they've gotten better from the 2004 version, to the 2018-19 version. There's much more objective, clear, 12 air changes per hour, every quarterly review of this. Where there is some area for interpretation is, frankly, some of our California laws have room for interpretation.
Right. No, I'm not saying that everything has to be precise. What I'm saying is that some of the language that was used was unhelpful in saying things like, we believe that this is what you should do.
Yeah, should to shall.
That's not
Yeah,
something
the
you
should
can
and
enforce.
shall, yeah.
Yeah.
But I think what I'm trying to, again, because pharmacists are asking what they need to do, and they're trying to figure out how we're going to, it's a merger and acquisition, USP and California regs, and I think it's going to be important to either create the exact same language that USP has and then add California standards. That's what several states have done, because I inspect for a couple of states. And so USP is the baseline, and then you have to basically be trained in that state and learn that, for example, one state requires 40 hours of continuous education in a continuum course for a technician before they are allowed to do compounding. That's this particular state's above and beyond reg.
40
So-
hours,
Pardon?
40 hours of,
Yes, the pharmacists are required to do 20 hours before they even are able to prepare a sterile product, and the technician's 40 hours.
now, are there particular courses in that state? Because that kind of education is difficult to find in
It is.
California.
It is, and there are in that state. Yeah, yeah, you're right. So, let's see. Okay, I think that was all my comments. Thank you very much.
Okay, thank you.
Steve Gray again, pharmacist. I was there and lived through when we started a long time ago in doing the regulations, and I have a couple of suggestions. One, given what you just talked about in terms of the strategic goals for the enforcement committee, given what all has to get done on compounding and going through all of that and be ready by December 1st, 2019, perhaps you should think about separating the two committees again. We had a compounding committee, and then later as we progressed, we merged it with the enforcement committee. It may be just wise now to start talking about separating the two and having them move down their own separate timeline and get things done. So that would be my suggestion, having been through this now for, 12 years or whatever it's been, in terms of the process. The other thing, I just came back.
Compound committee started in 2003.
Was it?
No, it was actually sooner than that because we got the legislation enacted in 2001. It started in 2002.
Okay, right.
See, I knew it was a long time ago.
And it seems like every bit of it.
I just came back from the ASHP annual meeting in Denver, and that's the meeting for ASHP where you get a lot of people it's where they have their House of Delegates, you get the policy wonks, you get the people that are involved with making laws and regulations and professional policies, and they were all asking, well, what's California going to do because of the new 797, 795, USB 800, and all we could do was show them the material, that was on your website was the latest. But I know I don't think, and maybe I'm wrong, that you've added this, you've introduced this legislation in 4122.5. Has that been introduced?
Yeah.
Okay.
We can't even agree what this means to us right at the moment. We're not going to try to take a bill through with that provision in this year. We need the time between now and the beginning of the year to work through that.
And just looking at this right now, the one thing I would suggest is, I unlike some of my colleagues who just want to look at 797, I completely agree with the last phrase that says, this does not, however, prevent the board from adopting regulations requiring additional standards for compounding drug preparations. I don't think it would be wise to limit yourself to additional standards. I think it would be wise to change that wording to say reducing standards or substituting standards or something. And if you think about it, if you think about the timeline that we have all experienced for the revision of 797 and 795 and 800, there may be something that is important to California that needs to move on a faster pace, or that was overlooked in 797 and 795 revisions, et cetera. So there may be a need not to just add an additional standard, but to actually substitute a standard or eliminate a standard that has proved detrimental. And so I think sometimes those words get, 5 years down the road, get interpreted literally, and all you've said is you can require additional standards in this language. Alan, do you kind of get where I'm coming from here?
Yeah.
So, and I just, like I said, since 2003 or 2 or whatever it was, you need to leave yourself some room there so that you can do something in a more timely manner than this whole process. Thank you.
Thank you, Steve. Any other public comment? Ms. Cotman, you sure?
We've got Christine.
Oh, Christine,
Can you
okay.
come forward, or do you want us to, I can bring you a microphone, maybe.
What do you want to talk about? We're talking about all the USP.
Hello. All right, Christopher Lee, the principal consultant for Dynalabs. And I just had a couple points that I wanted to go through really quickly with the adoption of 797. And again, I understand the emphasis on the fact that the revision to that chapter is being rewritten, and we're not sure exactly what those changes are going to incorporate. But particularly, there's some concern that I'm seeing from our clients that I get a lot of questions from, directly focused to beyond use dating and stability studies, stability indicating, as we're all aware that's a point of major contention. So as it stands right now, the current revised chapter of 797 that was previously published sets a maximum beyond use date of 45 days frozen. And there is no provision in that particular revision that states that stability studies could be used to extend the dating beyond that amount.
So 45 days is the limit.
That's it. That's it. The current chapter of 797 that was published in 2008 that is technically effective right now, and I'll kind of read exactly what it says in that, allows standard BUD dating in the absence of sterility testing, and then it relies on 795 for standard dating that's applied to compounds. But in that current version, it says that it should be recognized that the only truly valid evidence of stability for predicting BUD can be obtained only through product-specific experimental studies. And it further goes on to state that because beyond use dating periods established from product-specific data acquired from appropriate instrumentation are clearly more reliable than those that are predicted theoretically, the former approach is strongly urged to support dating beyond 30 days. So with the new revision, in some ways they're kind of contradicting that. Now, hopefully, when they publish the new one in June, they've addressed that, because I feel that by going with a standard 45 days, and I think a lot of our clients feel this way, and I think anybody would, in particular, I come from a GMP environment, so to ignore established science that is used to apply dating to manufactured products, if a 503A or 503B facility wants to spend the money and time to improve their process and invest in getting actual scientific data to establish dating, I think it's important that regulations be written so that they can do that. By restricting them to 45 days, in some ways, it's almost encouraging a lack of data generation. And that's some of the questions that I'm getting from clients, is basically, with this new revision, if it stays as it stands right now, does that mean we don't have to do any testing? We can just put 45 days frozen. Some of the concerns with that are that I can tell you from testing and experience that there are some drug products that aren't suitable for even 45 days. And certainly there's drug products that can't be frozen. In the revised chapter for 797 as it stands now, The goals with those established dating and the 45 days were really based on purely on sterility as a metric. They weren't taking into account potency of the drug product when they established a 45-day. They're just saying, from a microbial contamination standpoint, by limiting it to 45 days frozen, you essentially would mitigate some of that risk. I can tell you, as being part of a third-party contract laboratory that tests pharmaceutical products, while sterility is definitely a major concern and really the whole reason why the DQSA was passed and we've created 503B and all of these different entities, the largest failure that we see in testing is actually in potency. So of all the samples that we receive, less than 1% of the total samples, and this is nationwide, actually results in a sterility failure or a microbial related issue, whereas closer to 18% of all the samples that we test are failed due to potency. So
What kind of parameters are on that? It was like after X number of days, or?
it's not, the data's not really, that's just a total failure based on the specifications that the client would provide or what they're trying to meet, whether it be a finished product that's labeled as a USP product and it would need to meet those standards through that dating. It could also be related to actual data obtained from time studies or stability studies. So that's a total number of failures from when you look at the entire data set.
Well, that's
How
a-
far is the range of the potency that you're finding
So
on that 18%?
So that's kind of the shocking value. So when you actually take out some of the data points, the outliers that are there, the range would go from 0% potency on those products up to about 980% potency.
For those 18%? Now, what type of products are you testing? Are they injectable, hospital?
This is non-sterile and sterile products combined. This is the total of compounded products. So it's not stratified by sterile versus non-sterile or topicals versus injectables or by dosage form. It's just a large data set, so that data could be stratified down. But I just
So one-fifth of the products that you get don't have the correct potency, and it ranges from 100 times to 0? My God, I mean, this is
zero to over 900%.
Times, I think you.
My God.
Yeah.
Well, that's quite concerning.
Should be.
It is. Not that it should be. It is quite concerning.
And so-
Oh, good. We've got another comment there.
Yeah.
The idea that this is from compounders, right?
Yes.
That are coming to
And
you.
this is potency, it's not sterility. So
Yeah,
that's
this
the
is-
one that we would assume would be the most
Right.
accurate. Because it's using a master record and there's formulas.
Ms. Common has a,
Hopman, acting, can you hear me? Acting as an individual, to
speak up a little more.
hopefully can get some
The
clarification on
mic.
these data points.
Mike, Marie.
It's green, it's green.
Yeah, but you get closer to the mic.
We wanna hear what you have to
can't
say.
even hear
Mic,
you.
love the mic. Get a little more clarification on those data sets. I have sent creams off for potency testing that were at 100% the first time, 100% the second time. Let them get out to 6 months, 9 months, 12 months to see if I could extend dates. And at 9 months, it went to 80%. And at 12 months, it went to 50%. Obviously, we didn't put a beyond use date that exceeded the 10% limit, but those data points sound like they're included in your 20%. Is that correct?
The ones that are extended out
Yes.
to instability, potentially, could you? Or it's just within the stated specification for the expected?
Because if
Do
those
you
are
have a
included,
report with the data? I mean, would it be helpful to see where you've taken and how big your volume is and what time length? Is this like a study that you performed with parameters?
Yeah, it's just, obviously we have access to all of the data that comes in.
Well, I
and so
know
we-
that's what's so
Yeah.
concerning.
And so we
I
can
see-
perform
I see your
analytics on it.
point
Yeah,
here.
and I see your point too. So I'd be interested in seeing if that rate is exactly the same for those that are considered within a time study. But if it's just in release testing, so if we actually stratify that out by stability, and Christine's going to pull that number and I can come back up and try to get that data for you. We could stratify the data purely based off of release testing or confirmatory testing and take stability out of it and provide that rate.
Well, what you're saying is quite an indictment for all compounding pharmacies.
And again, and this is not, it's not saying that there's, there's no faith in compounding. I'm a pharmacist by trade, and I've been a compounding pharmacist. And coming from a CGMP environment where there's certain levels of process validation and things that need to occur in order, to ensure in a CGMP environment that your process is designed to meet the requirements through all phases, which is very much part of the CGMP processes, these things aren't really, those types of things are not in 797. And technically, compounders should not be held to that standard as a compulsory method, because it's very cost
I'm
prohibitive.
still concentrating on that.
797 also wouldn't apply to the non-sterile, so that would be.
Correct, right.
And also what concerns me, though, I can see Marie's point on the beyond use dating, but the ones that are over 100%, you said it went up all the way up to 980%. 80%.
Yep.
So that wouldn't account for the over 100%.
Correct.
How much of them are over versus under?
That we could probably pull that data set as well.
Now, we're sure of your testing. It's
Yes.
not the test,
So
it's
this
not the
would-
testing that's incorrect.
No, this would be on results that, this would be data that was resulted following internal investigation that ruled out lab error. So that would be those samples that have already, ruled out the laboratory error that occurs.
I'm quite concerned. We have to follow up on
Yep.
this. Absolutely.
Is the 980% after a period of time, or, so it actually got stronger with time? Is that, or did it start out, you just didn't measure it, and at the point at which you measured it, it came out at a 980%?
It was just the point at which it was measured, it was 900. So in
I was
terms of
wondering
the,
what in the heck kind of compound grows like that?
I mean, there are,
Evaporates.
that what it
there's
is?
a
Is
potential
that-
for
no,
products
maybe
that are
it's serious.
very high in alcohol content to actually increase in potency over time as alcohol evaporates out of the product.
Right, that makes sense.
Yeah. But, moving forward with regard to regulation and adoption of 797 directly or USP chapters directly, I think it's just important to understand the potential challenges that might be present from the lack of information that's collected in that, particularly with regard to stability and stability studies. I'd hate to see, as an industry where a lot of compounders have invested a significant amount of time and money in extending their data, their dating on their product, to all of a sudden be not allowed to utilize that data to support extending those dates. And thereby, not being able to have that extended data, you're limiting patient access to these products as well, because batch sizes have to be scaled down.
Wait a minute here. So what you want is the ability to use printed data about stability?
Not necessarily printed data, actual product-specific data that the client generates
So
from
like-
their compounded process.
From their compounded pharmacy?
Allow now.
What you allow now, yes.
Yeah, but somehow, that 18% sticks with me here. And so, is your implication that of the products that are out there, that 18% of those sent into you don't have the correct potency?
I mean, certainly it's a possibility, absolutely.
And how big is that data set?
Time period. Doses?
Total batches tested.
2018 potency, total count 7,800 tests, and 13% IR rate. So 980%, the highest. That was in 28 so far, year to date, 2018.
To us again,
Okay?
sorry.
No worries. You want the 2017 and the 2018?
And Christine, is this above or below, or is it both?
That would be any deviation.
Any deviation? You don't know how much is
Classification.
above or below?
2017.
I think that what we are telling you now is just kind of a broad, get this numbers together, but we can definitely get more specific with it for you.
Yeah, I'd like for further information on this. And Steve, have you got something to say here?
Of the client specifications, yeah.
Steve Gray. Steve Gray, pharmacist, and I've done a considerable amount of compounding and training. I think one of the things you have to keep in mind, especially for 795, is when you're measuring potency and you're looking at products, you need to look at what would the FDA accept in terms of a range for a similar product.
Right.
The data you were given here was based on what the client asked for. So 100 milligrams, tell us, whether it's
So it's not
105.
plus or minus 5%.
But it could be. It could be. They would have to say, well, when did it fail? Did it fail at 106 when they asked for 105? 95 to 105.
Mm-hmm.
So I think
Or 10%
I think
or
Christine was really trying to say is let her give you a full report with more of the parameters, and then it would also be important to find out kind of under what standards were these pharmacies doing this? Was it California standards? Was it Louisiana standards? And I'm not picking on Louisiana, but they cook real good down there, and so I know that they know how to make things. It's a complicated picture. It should be concerning when you hear numbers like that, but I would recommend you drill down a little bit and find out what's going on. There are some products, and this may have changed, that I know that the FDA allowed a 20% either way in terms of labeled potency, some products, and because they were looking at also from a therapeutic point of view.
Right.
If you're using a cream, it's not like a capsule or a tablet. The prescriber says, spread this on your leg, and some people will use a spatula and others will use a toothpick. And you dose it according to what works and what you need, not necessarily to in the cream. So I would just say back up a little bit, but I think he made some good points that there's some wide ranges out there. And then how many pharmacies were in this sample? I mean, are we talking about 1,000 pharmacies or 500 that knew they might have a problem, so they sent them in for testing? I don't know what the whole picture is.
Yeah, I mean, my primary focus in presenting that data, even though it's broad, obviously can be stratified and it can be laid out just as he said, because it is important to understand what states these come from. There are certain states which have very little regulation at all. I live in the state of South Carolina, and from a sterile compounding perspective, they barely have anything.
Okay, so these are not all from California.
They're not all from California.
We can let those
but-
other states
yep.
suffer on their own. Okay.
Exactly. But to my point,
Dipping in, yeah.
the point of the comparison was just to show that the failure rates relative for a microbial issue compared to a stated potency, there's a significant difference there. It's not a consistent failure across the board. And I know that the focus is primarily on sterility because that is the event that occurred that caused so many issues and so many deaths related to the New England Compounding Center. It's just the focus is so heavily on sterility and microbial contamination that the emphasis on assuring that you're within a certain range of your stated or labeled potency or concentration is seeming to wane a little bit. That's just the emphasis that I'd like to put on that. But in terms of the data set, we could get that data stratified out and organized in a little bit better way.
Yeah, we'd like to see that,
Yep.
definitely.
It would be good to see also how much it's sterile versus oral, the dosage form.
Sure. Yep.
No more public comment?
Any more public comment?
I mean, that was really interesting. Who can top that?
Do you really want to?
No, any more comments about Ann? What are,
Well, I guess if, so I've heard that it seems like in the retail area, and please correct me if I'm wrong, in the retail area, they seem to be able to be achieving the compliance with respect to the physical construction requirements for USP 800. Is that correct? Did I hear that correct? So
This isn't working
So
for
it's
us.
sounding
We can't
like
hear.
perhaps. Yeah, so it sounds like Dr. Partridge was referring to independent pharmacies. So I think one of the outstanding questions is it sounds like maybe independents are okay. I don't think we've heard from from maybe chains that maybe are, do the hazardous compounding where they are, or any hospitals or
Right.
anything. So from at least my perspective, I think it would be helpful to know how things are going in that area as well.
Well, since this is going to be a standing agenda item, I think perhaps we can encourage members representing those entities to report. And we can.
Future meeting.
At future meetings, yes, which we're going to talk about shortly. Okay, no more board discussion, no movement. Oh, and Steve.
Steve Gray, pharmacist. In my career, I've been fortunate or unfortunate enough to also be active in ordinance matters at the city and county level. Something I think just needs to be on your radar. At various cities and counties, they're starting to have discussions related to all this USP 800 and harm to employees and so forth. And some counties now are considering their own ordinances about protection of the public. I know in one city, I think they've adopted it. They said that if you're going to vent these things to the outside, there were concerns about how close they were related to schools, related to neighbors and so forth. And I know in my own experience, when we were using ethylene oxide to sterilize plastic products, I had to go to the houses within 1,000 yards of our facility and prove that I had informed those residents that we were going to be venting ethylene oxide to the outside atmosphere. No longer do that. They use something else to handle that product. But just to be on your radar that during this process there may be some community pharmacies or even hospitals that are having trouble meeting local ordinances that have popped up.
Thank you, Steve. Okay, so next topic. Discussion and consideration of possible board policy relating to transparency involving the issues of fines and citations. Background. During the April 2018 Enforcement Committee meeting, the committee requested the board staff survey all DCA healing arts boards to determine how each of the board handles general transparency related to the issuance of citations and fines. All DCA, and the consideration is all DCA healing art boards were surveyed to determine whether each board had posted citations and fines on their websites. The survey showed that 15 of the 18 boards post citations and fines on their website. However, the duration of this varies. It should be noted most of these boards surveyed are actively using the Breeze system, which may be programmed to upload citations and fines to the respective sites. The chart below identifies boards surveyed and whether boards post citations and fines, the length of time that they're posted, and on whether or not they participate in the Breeze system. Now, we do not, so does that say that since we don't use Breeze, does that mean that fines and citations, that's beyond the scope of our computer system to put those on there? Or?
There's one board that is not on Breeze that posts, and that's the sample that we provided, how it's done for chiropractors.
Chiropractic board? That's on there for 5 years. So acupuncture, pharmacy, registered nursing, and what do we got? Naturopathic do not. And the rest of them do.
Okay, can I make a motion, Chairperson Shad?
Please.
I'd like to move that we investigate what it would take for us to post citation fines on our website, or at least provide that information as publicly available.
Second, Greg?
A number of them post for 5 years, some post for 3 years, some post for ever. So
Eternal is nice there, yeah.
yeah, eternal. So
Kind
do
of,
you-
kind of ominous, yeah.
yeah. Do you want to include some time period in
Yeah,
your
that's a
motion?
good point.
Yeah.
We could do, what do you think about doing 3 years? Seems like everybody,
I think that's a good start.
did a good start?
So I'll second that.
I'll just take this opportunity. I know that the full board's going to make this decision, and it's just a motion, so I'm not speaking against the motion to the extent I would
But you
ever
will
do.
be there.
But I just want to remind this committee in the same way I'll remind the board that, as I mentioned in my timeline presentation,
Elegant presentation.
this is going to make, doing so, I think would make it much more difficult to reach settlements in citation cases, and many more of those cases would therefore go to hearing, which would necessarily add to the workload and delay both those cases and the other cases that the board brings. So just keep in mind that everything has a consequence, and one of the consequences of making a more public display of the citations is that people have a greater reason to fight them.
I think that there needs to be probably then a review of what we're going to issue a citation for as
You
well.
know, this motion is just to look into it. It's not to.
Yeah, it's to look into what
Right.
can be done, how can it be done, and present the facts to the board.
So, second.
Great. Public comment?
Steve Gray, pharmacist. Of all the things on the agenda, this was the one I was most concerned about, if we didn't pay attention to some unintended consequences. So for an example, if you look at in the attachment, I believe that was the chiropractic board that was in the materials for the attachment.
Right.
And you read carefully and think about all the disclaimers they've had to put in there to talk about how these are not final, some of them are incomplete. What are you really saying to the public about these, and when? And what could be the unintended consequences? I don't know if those disclaimers are uniform. In other words, the medical board has the same disclaimers, and the other ones that actually do say they post them and so forth. But I would really caution you to really look at how good is the data that you're posting, and when is it posted? Is it posted only on final and after all appeals and all that kind of stuff? I agree with Josh. I can tell you from experience that it will, the more you post and the more adverse it may give to a business that is trying to keep its community, reputation, the tougher it is going to get to settlement. And, because it could destroy their business just having one citation posted or something. The other thing I was concerned about is when you look at that example of the chiropractic and the way it's laid out, we already have a significant problem with the board in differentiating between discipline and a citation. And if you look at the way that's laid out, someone could look at that and say, well, those citations are part of discipline, because the bold heading on the way it's laid out, it says discipline, and then below that you have a smaller, different font that starts to talk about citations. And so the implication in just the way it's laid out is that all these citations and fine are a part of formal discipline. And then so someone starts looking at it, especially from out of state, and looks at a pharmacist or a pharmacy or a hospital and says, oh, they've got a long list of disciplinary actions. And of course, executive officers always said, well, we'll send a letter and say that they're not disciplined. But meanwhile, as you heard earlier, they're going to get, because they've got a license in that state, they're going to get a notice that they're going to get disciplined in that state because they were disciplined in this state, and it's the same entity. So there's a lot of things about posting and the possible adverse consequences that could really be adverse. What if it's a pharmacy and there's no other pharmacy within 100 miles, a rural pharmacy, and they get one citation for an error and it destroys their reputation, and now suddenly they have to go out of business because you've cut their business by 30%, which puts them in the red. So, really, what are you trying to do here? And you talked earlier about some of the consequences of true discipline and how that had such much more damaging effect than the board thought it would have because of the economic and other situations. So I would say I think you need to study it, but I think you need to go very cautiously down here, before you just say, I'm going to post every citation, letter of admonishment, or, order of correction.
No, I think you are absolutely correct. The thought of the consequences of this should be discussed in detail, and it's not something to be rushed into without plenty of conversation behind it.
Right.
Yeah.
Right. It might be good for the pharmacy attorney business, so maybe I should be.
That's right.
There's also, if you look at the list of boards that do this, the medical board does it. A lot of the healing
much
arts
all of
boards
them.
are doing this.
But that's a good example. The discipline process for the medical board and what they have to go through before they can even start a discipline is entirely different than the pharmacy board. And so it would be important to know the yes or no is not enough information. We don't know what the medical board actually posts, and we don't know when they post it in the process. And so that's a good example to point out. There's so much different about the way the medical board by law has to go through an entirely different process with retainer physicians on board to help them and all kinds of stuff.
Thank you, Steve. You'll be here to follow up on this, right? Yes, sir. Good. Good.
Danny Martinez with CPHA. So echoing a lot of what Dr. Gray said, and one thing I'd also like to add on as you guys look at what particular parts of this you're going to study, I think, because we heard earlier that a cite and fine can be anywhere from something minor all the way up borderline to a discipline issue, right? So I think hopefully, the CPHA, we don't want to protect bad apples, but at the same time, we want to give people their due process. And if it's a minor issue, obviously, one of the things we'd like to see is that notated, whether, how it's reflected that it's a minor, I forgot, whatever, as
Right.
opposed to, because the inability from any regular consumer to differentiate what's minor and what's not. I can't. I'm not a pharmacist. I could not look at that and go, is that major? Is that minor? And then
That's a good point, because over half the board is pharmacists. What we read in there is entirely different than what the public reads.
Correct.
Yes.
Yeah. So just keep that in mind.
So I think, Dan, you make a really good point, because we have to look at what the public consequence is going to be. Will it cause them to lose faith in their pharmacy also, to see the fact that there's a citation listed in there?
Which would not be good for public health.
No.
public safety.
Yeah, definitely.
Yeah.
And I think our original discussion, the reason this all came up is I think the board members want to know more about it. So maybe there's a way we can find out how the board members can do it. This was just illustrated as a solution for that.
I understand the value of looking at other healing arts boards and seeing what they do, but again, as Dr. Gray mentioned, what they do and what pharmacy does aren't necessarily compatible, and so I'll just end my comments there. Thanks.
Thank you.
Steve Gray, pharmacist. One of the experience I had was dealing with this issue in another state, a very large state called Texas. They may be another country. I'm not sure what they were.
It is a different country, right? Yeah.
Yeah. And the other thing that they did, which seemed to be very unfair, was that they posted it related to the entity that owned the pharmacy, and so as opposed to each pharmacy. So if ABC Corporation had two pharmacies, they're both a corporation, and XYZ Corporation had 200 pharmacies, and you post the number of citations for dispensing errors, then it really looks unfair, because if you've got 200 pharmacies and they're all filling 400 or 500 prescriptions a day versus two pharmacies that are filling 125 to 150 prescriptions a day, and again, what does the public see? They see this number for the large corporation and this number. So we tried to get them to say, well, why don't you post it per location, because that's what really counts, So again, how do you the example that we shown in the materials was only for a chiropractor, an individual, and it isn't for a chiropractor corporation or a chiropractor business. But in pharmacy, we're different. We have individuals, we have pharmacies, we have hospitals, and so the quantity or the magnitude may send a different message just on the way that it's presented with the data.
Thanks. All right. Love this discussion. And somebody's behind you, too.
Robert Stein, KGI School of Pharmacy. I respectfully disagree with the previous two public speakers that the purpose of the board is to protect public health and safety. That means that consumers should have the right to know whether or not a healthcare provider has had a problem or not, and then make an informed decision. Now, does that have the risk of potentially causing some businesses to potentially lose some business? Yes, but I think it also should be encouraging all pharmacies and pharmacists to follow the law so that they don't get cited in the first place. Thanks.
Thank you.
Clarify a small point. The information in a cite and fine is publicly available. They have to request it. So it's not that we don't release it. They'd have to ask for it. And the same thing is true for license verification. And the media routinely will ask us for what kind of medication errors have been reported to the board. And there we will search on the code section and give them the list of everyone we've cited and find that way.
Okay, Paige Talley, CCAP. I have a clarification question and then a comment. Are we talking about citations and letters of correction that don't involve a fine, posting those on the website or somewhere? Because
well, Amy's motion was to look into
to
it.
investigate.
So you're right. So
Look at options is what I
Right.
mentioned.
and so we can't answer that.
Okay.
No, I mean, it's certainly consideration.
So I would
Yeah,
hope not, because if it's something that's not final or it's something that's not really punitive, there are PBMs that will tell the pharmacy they can no longer process their claims, and they lose those patients and that revenue
Yes.
based
that
on
is-
something like that. And I mean, I know several.
Right.
So that's a concern also.
Okay.
Thank you.
Yes, that was mentioned. I mentioned that earlier in regarding unintended consequences. And so, but you're referring to a specific.
Even just the letters of correction, and if those appear, there are PBMs that.
Unintended
it happens all the
consequences,
time.
right. Okay.
But it happens also when it's the hearing is final and there is a penalty and they're on probation or revoked. It also happens. And that, I understand why you do that. But for something this minor, I just don't think it should be there.
Okay. Thank you, Paige.
Hi, Robert Stein, KGI School of Pharmacy. If the issue is PBMs contractually terminating because of things like a citation or a order of correction that are not considered disciplinary actions, perhaps a statutory requirement that they cannot contractually do that as a breach of contract would solve that problem. Obviously, if there's a disciplinary action, an accusation, and an ultimate decision by the board, absolutely. But citations generally are of a violation that's significantly less
Right.
critical and important to public health. Thanks.
Okay.
Ready to vote?
All right, we got a motion
Yep.
and a second. All in favor?
Can I just ask for a little
Oh,
bit of
uh-huh.
clarification on that? So the motion is the motion you're directing staff to investigate how to post it? Is that, that's
review
what it
options
is?
for posting.
Review
And then
options.
also parameters, Ann, like, make sure they're only citations that have already been finalized and they've been paid or whatever it is, or, not the ones that are pending. And
Right,
how.
so once the citation has become final, any
Yes.
appeal times have been done, those kinds of
Yeah,
things.
kind of that type of
But
parameter.
you're looking at parameters for us on both posting mechanisms and then the conditions under which it would be posted.
Yes.
Right, I just wanted to confirm along those lines, what I was just asking Mary Jo and Ann was that of the client agencies that were surveyed, Mary Jo knows the actual data, but some of them post when it's first issued, before it's been affirmed or appealed. Some of them post only after the citation or fine has been paid, so essentially once it's been acknowledged. One client agency only posts it when the citation is appealed for whatever reason.
Right.
Yeah, so yeah,
seems
it's all across the board. There is no uniform policy.
That's what I kind of asked her to come up with, what the recommendations from the staff is as far
Right.
as what would be best so that the board can see options. That's all.
So
Those are good
in
points, Josh.
completing the vote,
Leading the vote,
Are you,
yes.
yes. Are you okay with the clarification? Okay.
All in favor? Unanimous. Again, no.
did you count the opposed?
Okay, number 4, discussion and consideration of laws and regulations related to petitions for the reduction of penalty, reinstatement, etc., of discipline licenses. Relevant law. Business and Professions Code 4309 establishes conditions under which an individual may petition the board for reinstatement of license that has been revoked or suspended. It also establishes conditions under which a licensee may petition the board for modification of a penalty, including probationary terms and early termination. The section further specifies timeframes that must be satisfied before a petition can be considered. At least 3 years for reinstatement of a revoked license, at least 2 years for early termination of probation, at least 1 year for modification of condition or reinstatement of a license revoked for mental or physical illness, or termination of probation less than 3 years. This section also provides that a petition cannot be considered while the individual is under sentence for a criminal offense or court-imposed probation or parole. In addition, the petition cannot be considered if there are additional accusations or a petition to revoke. Background information. In recent years, the board has considered such petitions at specially convened board meetings where the primary focus of the agenda is consideration of such petitions. Although the law allows for different adjudication processes, the board's policy in this area to convene these petition matters as part of the board meeting whenever possible and to have the hearing presided over by an administrative law judge. Following the hearings, board members meet in closed session with a ALJ to deliberate on matters presented during the open session. Once the board makes its determination, the ALJ drafts a decision on behalf of the board. In the event of a quorum of the board not being achieved, the board's policy allows for petitions to be heard by a committee of the board. In such cases, the ALJ will draft a proposed decision for each petition, and the decision then will be considered by all members as part of a mail vote process. Under the law, a third option also exists where petitions are considered by the ALJ independent of the board. In such cases, the ALJ renders the proposed decision, which is then considered by all members as part of a mail vote process. In all three scenarios, the respondent provides a packet of information and supporting materials intended to provide the board with information in advance of the hearing. Such information includes personal information and license history, letters of recommendation from citizens, and continuing education. The respondent is also afforded the opportunity to provide oral testimony under oath. In addition to the respondent's testimony, a representative of the Attorney General's office is present and represents the people of California. The AG's office is allowed to question the respondent as well as any witness. Although not done in all cases, the AG's office may offer a recommendation to the board on the outcome of the petition. Technically, the board does not have representation in these petitions, then typically the board staff does not offer testimony. Since July 1, 2015, the board has considered 41 petitions, including 26 petitions for early termination, 2 petitions for modification of penalty, 13 license reinstatements. Decisions are not final on all the petitions heard, but those who have been rendered, 13 have been approved and 17 denied. More specific details are in attachment 2. Now for the committee discussion. As provided in law, the board may consider factors including, but not limited to, the following: all the activities of the petitioner since the disciplinary action was taken, the offense for which the petitioner was disciplined, the petitioner's activities during the time that the license was in good standing, the petitioner's documented rehabilitative efforts, the petitioner's general reputation for truth and professional ability. To assist in the collection of the relevant information and to provide guidance, the board has developed petition packets that detail both required and supplemental materials sought from the petitioners and some FAQs about the process. The criteria established in law is very general. Staff is hopeful that the committee will provide policy guidance recommendations that ultimately can be considered for the full board when considering petitions. Such policy discussion will assist staff in ensuring the petition information collected is meaningful. Some questions the committee may wish to consider include 5 items here. 1, is the current process for hearing petitions sufficient, or should the board consider reevaluating its policy? 2, would it be helpful to have the board staff testify regarding compliance with terms and conditions of probation, rehabilitative efforts demonstrated by the respondent, public protection concerns? 3, would it be helpful to request additional information in advance of the hearing from the petitioner to aid the board in making its decision? 4, does the board wish to establish additional parameters a petitioner must satisfy prior to being eligible to petition the board? 5, should a time frame be established that provides clarity on how long a petitioner has to satisfy the requirements set by the board for reinstatement? That is, to pass the NAPLEX, or the CPJE, or pay fines, etc. Attachment 2 includes a copy of the BPC section and a sample of the petitioner packet. Now,
I have a couple of comments.
okay, great.
Question. Number 3 on the some questions to consider. Would it be helpful to request additional information in advance of the hearing from the petitioner? If we go back into the attachment, the instructions for filing say in the Q&A, preferable and to your advantage to make every effort to submit all relevant documents with your petition 90 days prior to your hearing. So it already addresses that here. However, it seems to me that we normally only get the documents a few days or maybe a week before the hearing. So the question is, are people reading this and following this and sending them in and we're not getting them till the end? Or are they not sending them in? One item. Do you know if we...
No, a little, we actually have the expert in the room, and Ann may know more than I do.
Okay.
If they didn't submit a petitioner packet per se, they wouldn't be scheduled to appear before the board. But what constitute a complete packet varies a little bit, and then there's some validation that the board staff does to verify the information that's in the packet, and sometimes it isn't complete. Sometimes we go back and forth and request more information, but I don't know, is there something more you can add, Ann?
I think that one of the, so like Jenny said, similar to an application, right? You submit an application, but if you haven't given us everything we need, there's opportunity to collect that. But I know that one of the challenges that we do have sometimes is being able to validate, especially the letters of recommendation and getting people to return calls and those kinds of, because as part of our due diligence, we are validating that people did in fact submit the letters, that it is true statements and those kinds of things, because the information is all coming from the petitioner. We're not requiring it directly from those secondary sources.
But without a basic app, they wouldn't be put in front of you.
Okay.
But I think
but
what Greg's referring to here is if the board, on review of the cases by the board member, if we want to request something,
yeah,
it's impossible to do because of the time frame.
right.
Right.
Well, sometimes I think in all fairness to the petitioners, when they submit this, they don't know when they're going to be heard, right? I mean, they don't know.
Right.
So I could submit this today and I could be heard for a year from now. Or it could be a year and a half or 3 months.
Yeah.
So maybe sometimes they don't know, and they may have some more recent information. And then when you set the date, then they know what to submit, right?
When you set dates, how far in advance do you normally set the date?
So we have the calendar for the one-day petitioner set a year in advance. So there's 2 additional ones, I believe, this year. And then we have, at the last board meeting, we set out the next 4 for next year, the specially convened ones.
Well, they know well in advance.
But we can't accommodate everybody. Sometimes our volume is, is more than what we can accommodate, so we do them in date order. One of the things that would be helpful in some of this is we go based on date order. So if you gave us policy direction that, people that are non-compliant, they, we don't put them first. We put people that are compliant. Give us a little more guidance on that. That will also make it easier for us to help identify petitioners and reach out and start doing some of it a little further in advance.
One of the things, I guess one of my points, or my main point is, if we are getting the information sooner, it would be helpful if we received it sooner.
Are you thinking, do you want it, so agendas are typically not set until 10 days ahead of the meeting. And that's when we have pretty much finalized. We know that we've got an ALJ, we've got everything lined up. So if we provided it to you the day that we released the agendas, I'm trying to get from you what would be helpful. So that's
anything better than a few days beforehand would be, preferable. So
okay, so guidance to the staff would be the day
days.
that the agenda is released, the petition materials are sent.
Right.
And then that makes it, the weight is on us to read those right away so that if we need something, we can.
Because a lot of these, are hundreds of pages long. And,
That's
nice
true.
to go through them a little sooner. The other thing that I wanted to mention is that in these instructions also, it says petitions are scheduled during the closed session portion of each board meeting for the hearings. Yet, seemed to me that, we have some that are done during the open meetings and some done in closed. How do we distinguish? Because yesterday we had both a reinstatement of a revoked license and we had petition for early termination. And
So the one that's generally in, so you hear the petitions in open session and then you go into closed session to render a decision. That's different for a petition for reconsideration, which is an entirely different thing.
A petition? Oh, go ahead. So I think that the cases that you hear testimony and you take evidence about, those are called petitions for reduction of penalty. And it can either be early termination or reinstatement. Either way, you're reducing the penalty that the board imposed, either
And that's all we're
outright
talking
revocation.
about here, is reduction of penalty.
Right. So, but those petitions require an evidentiary hearing. They require that the board takes and hears the evidence that's being presented. So to accommodate that, how you conduct that is by having it here before you, although I think in the materials it's also included that one of the ways that you can do that is certainly to delegate that to an ALJ. Does that make sense?
all I'm after here is, how do we determine whether we're in a closed session or an open session? Because sometimes we have hearings in closed session and other times we have an open session, and I'm just wondering.
I don't believe any case where you would hear and take evidence will be an open session.
So the ones where we meet with the client and the judge and so on, closed session is
It's only deliberations that occur in closed session.
only deliberations.
Right, with the judge, right?
Can I ask on the questionnaire that we give them, question number 15, can we clarify that? So, because sometimes we give them this questionnaire, it's kind of a gotcha, but can we say, except for this case?
Oh, yeah.
Have you ever had disciplinary action? Because sometimes they get confused when they're answering this question, right?
Oh, a lot of them do.
Yeah.
A lot of them don't realize that administrative is, what we're doing. And so they see the question about, have you ever had a criminal or a complaint? They read it as criminal and they don't read the administrative part.
Well, it says, have you ever had disciplinary action taken against your pharmacist license in this state or any other state?
And sometimes they figure, well, you're already filling this out, so you know about this case. And some of them fill it out right and some of them don't, but I think it's a little confusing.
Okay, so we're talking about two different questions on the same form.
Yeah, I'm actually question number 15, Greg, on the
Okay.
second page of the questionnaire.
Okay.
Oh, the petition,
I know
right?
what you're talking
Yeah,
about.
Want them
the
to answer
petition
the question.
for reduction of penalty.
Yeah,
I just think we need to make it clear, if we're just saying, except for this case, have you ever had disciplinary action? Because I think that's what you're
Yeah, I
trying
think
to
that's-
find out.
I don't think so. I think actually the way that I've asked this question before myself. They actually want them to self-confess that I'm in front of the board because of the discipline taken that I'm now trying to end.
Oh, they think that that's a guilty plea by saying yes?
I don't, no, I think, no, I understand the confusion because I want them to describe why they're coming in front of the board. What was the gist of their violations, maybe?
Well, maybe we just clarify the question so that it's really clear.
Is that what you want?
Yeah, to clear to everyone, because otherwise what happens sometimes is we'll have the DAG ask them, so you said no, but you're here, sitting here at this hearing, so you obviously have had a reduction in penalty, you actually have a penalty, because they wouldn't be here if they didn't have a disciplinary action.
So you'd like them to paraphrase why they're in front of the board, the violation that led them?
No, I
no,
would.
she wants to say, except for what you're hearing now.
Yeah,
Okay.
because we already know about what we're here now.
Yeah.
Do you have any other discipline in any other state that we
Right.
don't know about?
No, I hear you, but I think the actual point was to get them to describe something, but this is only a yes or no, so they wouldn't be describing it anyway. So, yeah, okay, that makes sense.
Well, no, it says answers 10 through 15 is yes, you have to attach a statement.
Yeah, I think they wanted a description of the current. Not interested in having the individual. If you're not interested in having the individual give you that information back so that you can see what they're saying, and I agree with you, why ask it?
They already know
'Cause you
about it, right? They're here and they know they've had discipline and they're asking for a reduction of penalty.
But they're clarifying what it is in their mind that led to the discipline, what their disciplinary action was all about. And
So
perhaps I'm
I
not explaining this
think-
very well. I think that's what they're asking.
So
That's how it was explained to me.
If you look, I think the question that Amy's talking about is question 15 on page 2 of the petition. And I think what you're talking about, Jenny, is
I thought I was talking about
that,
15,
are
though.
you, you're not talking about?
I think it's an ambiguous question, which is. Amy's point.
16 specifically says, list the date of the action and explain the cause of the disciplinary
Okay,
action.
so that's already asked. So let's, except for this action, needs to be there, I agree.
Yeah, because 16, they'd have to probably, to your
Yeah.
point, list it.
That makes sense. Amy, here we
Okay.
go. Now Ann's
You
going
know-
to.
That we play this gotcha with them
No,
on
I
those.
agree. I agree with you.
I don't think I got my answer to the other question.
Ann wants to give us some illumination, I think.
Illuminate.
An item that would be helpful for staff is specifically, are there other conditions that you want them to satisfy? So if someone is non-compliant with their probationary terms, we're not filing a petition to revoke, but they're not compliant, they haven't done their CE or something like that, would that be something where you would give us policy direction to say, if they're non-compliant, we're not going to hear them in lieu of other people. Do you know what I'm saying? So instead of a first in, first out, we have the discretion to, if someone's not compliant, maybe push them to another meeting, allow them to address their compliance issues, and we can move someone else in that is compliant.
Yeah, and I think you also do geographical preferences also.
Generally give
I
them
know
the
when you try
opportunity,
to.
if they're in Northern California, but it's in Southern, we'll say, do you want to travel or do you want to wait? Generally, that's what we do, but we still keep it on the first in, first out. So, and then the other thing is, sometimes what happens with reinstatements is we'll give someone back their license and we'll say, you have to complete X, Y, and Z. They never do X, Y, and Z. And so that decision is just out there in perpetuity. Would the committee be interested in considering amending the statute to perhaps say that if a reinstatement is granted, the person has X, Y, and Z, has a period of 2 years to satisfy the preconditions for licensure, or would need to repetition the board in the future? Do you know what I'm saying?
That makes sense.
Well, it certainly makes sense, but I can't,
We have probably 15 to 20.
well, I'm amazed.
That there's, it actually, that might even be low. It might be closer to 30.
So they're just kind of like in limbo state.
Right, so you've said yes if, when you satisfy these conditions, and then they just never follow through, so it's kind of just out there in perpetuity. It would be nice to have some kind of some kind of provisions, and I think it would just be easy to put it into the statute that says, you know, if you're granted this, you have this amount of time to do it. And I don't think it needs to be like 60 days or whatever, but I think some sort of reasonable time period, a year, 2 years, something, whatever you deem it appropriate, but that's the concept that we'd like help with.
And how do we go about this?
Well, I think if you agree in concept, if you want to give us some parameters on what the recommendation would be, you want to give them a year, you want to give them 5 years, something, then we can draft some kind of implementation that could be brought to the full board. So you guys could say, this was our policy recommendation, and this is what could be used to facilitate it.
That makes sense. I like Ann's suggestion, because otherwise it's in limbo forever.
Yeah,
Yeah, I agree.
yeah.
What do we
So,
want to pick a time?
If it's helpful, for pharmacists, we generally give them a year once they pass the exams to satisfy all of the requirements. So a
Okay.
year might be a place to start with.
Well, let's make it a year.
oh, yeah, that sounds,
Motion to make it a year.
Second.
that's the end of the board discussion? Public discussion?
And just for clarification, so we'll work with staff to determine how you would go about accomplishing that, because I think you would need some.
Yeah.
I would
means to
assume
effectively
Yeah,
that,
we can do that.
we would need to let them know, Laura, when we gave them the conditions, right?
Oh, absolutely.
And I think because it's going to be a hard rule, it's going to need to be in the law. So we'll develop whatever the language would need to be.
Right, you might need to
Good.
amend 4309, probably, yeah.
Yeah. All right. All those in favor?
Did you do public
Oh,
comment?
oh, I did.
Sorry.
Nobody moved. Steve didn't move.
Uh-oh.
Oh, all right.
you dared him.
See?
You can't give them second chance opportunities.
I,
I keep hearing in the NBA playoffs. Cannot give them second chance opportunities.
I want to report as soon as I'm
He
done.
happened to be from Oakland. was
Steve Gray, pharmacist.
What part of the retirement was semi?
Daily. No, just a comment on another type of licensing board had a problem, or a regulatory board, I should say, had a problem because the evidence showed after thousands of cases that the petitioners were much more likely to get a negative response when they appealed when the board they were before were tired or hungry or both. And so I heard, you got, like, I don't know how many cases were yesterday, but let's say were there 6 cases yesterday or 5? 5?
Yeah, but one took about 3 hours.
Yeah, and I would just caution you, I know you have a lot more cases, you're going to have a lot more cases. I would just caution you on not trying to schedule too many. If you're only going to get the materials, and as Amy said, there's like hundreds of pages to read, and if you've got 5 or 6 cases and you only get it 10 days in advance, that could be challenged whether, actually anybody read it. And there are now in this particular regulatory situation, thousands of cases that are having to be reheard because the data showed that due to fatigue and hunger and a lack of time to review, they did not receive due process. And so you want to be real careful about how many cases you try to schedule all at once. And then the way whether you take breaks and et cetera. Because all that evidence came before the court, and the court ordered them all to be reheard.
that's fascinating. We voted?
Yeah.
Yes.
Oh, that was
no.
just,
You didn't vote, that was.
No, because we waited for Steve. Now we
that's
can
right.
vote.
Okay. All in favor? Unanimous again.
Gee, it turned out the same as it did before.
All right.
And my question, I think that didn't get answered, is, I think I just read it wrong, because the question was, how is the date and place for my hearing decided? And the answer is enclosed is a schedule of board meetings, dates, and final filing dates. Petitions are scheduled during the closed session portion of each board meeting. I think it says that the petitions are scheduled in the closed session, not that the hearing is to
Right.
be in closed session.
You're correct.
Oh, I read it wrong.
All right, number 5, discussion and consideration of potential statutory or regulatory amendments to allow reverse distributor to accept,
With respect to with the order of the petitions versus the first in, first out versus those that are non-compliant, I think that we might need a motion for you guys to give us that flexibility. I'm checking with our counsel. She was looking it up right now to make sure. Because there's not, the provisions of the law don't really give us a
Do I
lot
have a
of.
motion for that?
I think that that's probably a good idea, and we'll look at that too to see if we need to memorialize that more fully.
good.
I'm sorry, did you need a motion?
We were talking.
Yes, I would
I'll
recommend a
move it.
motion.
All right. So authorize staff.
Identify ways to get the in limbo people, right?
No,
it's to
no.
Prioritize,
First-
prioritize.
Oh, prioritize.
First in,
Got
first
it,
out.
got it. Okay, to prioritize.
FIFO.
Or rather,
Prior-
there you go.
prioritize those that are compliant.
That should be a
Probably
term
would be a
that,
better
Greg
way.
has.
That Greg knows.
Yeah.
That the
Yeah, I'm
be- and
spaced
it's-
out.
That board
FIFO.
staff believes
Oh,
are
FIFO,
compliant.
yeah, sure. First in, first out.
LIFO.
Yes. Yeah,
LIFO.
last in, first.
Last in, first out. That got grilled into my head.
I bet you never heard of NIFO.
No, what is that?
Next in, first out.
So if I motion, do we get a second? Greg, did you second?
It's true. They're all
When
inventory
you're right on
methods.
top of it, yeah.
Second?
Second.
Oh, okay, we got a first and a second. No board discussion. No discussion
Oh,
out
we
there.
were having
I'm sure.
plenty of discussion here.
Okay, all in favor? All right.
Is that FIFO, LIFO, or NIFO?
That was next
Want to go over the data? Because I know we've got, 40 minutes?
Yeah, we got 40 minutes. Let's move to number 6. Yes, discussion and consideration of current board investigation timeframes and performance measures. We've discussed this quite a bit. We've got the information here pending field investigations. Ann, do you have information on this that you'd?
So also what was passed out was some historical data. So in the packet itself, you have of our pending cases, how many there are in the different kind of benchmarky states right now and what the average time they've been in there. It's broken up by field investigations versus desk investigations. Field investigations are the ones that are done by our inspectors. The desk investigations are those that are done in-house, generally by our criminal conviction unit. So that's what the difference is. So you can see the team review for assignment, that's measuring from the time we receive a case to the time that the case is actually assigned. So we have 131 of them that are in that, or that are currently in that status, and the average days of those is 31. So I'm not going to keep going, but I just wanted to explain how the data is laid out. There, we do not have team review for assignment for pending desk investigations, because those are generally done within 3 to 4 days. So that time frame is really relatively small. So we have the pending, field, and desk. In addition to that, in the attachment, we have where we are in terms of the enforcement performance measures that we kind of mentioned earlier, and that's a department report, and their benchmarks are different. We break it down a little more granularly than the department does. Their data is a bit old. It's our understanding that they're going to resume publishing those, so that stuff's a little bit dated, so you can't really do a comparison at this point. And then what was passed out, which you should have, and I believe that there's some in the back of the room if they're still available, is the case volume and average days to complete for the last couple of fiscal years. So it's broken down again by those benchmarks, but you can see what the average days are for something to be done. And then at the very bottom where it says number of cases closed by outcome with aging, that is from received to closed within our office. So do you see where I'm talking about? It's at the bottom. So an unsubstantiated case in 17-18, for the first 11 months, we had 758 of them. The average days from open to close was 346 days. Stan had asked earlier, this is calendar days, not business days. So of the substantiated cases that have been closed, of which there were 1653, the average days was 329.
You know, what's the difference between,
Whether or not we substantiated violations.
Oh, we got to prove them if they're unsubstantiated?
If they're unsubstantiated, it means that we did an investigation and everything was good. No violations. And then the letters of admonishment, so that time is not only the investigation time, but then the time to issue the letter of admonishment. So that's why it's longer, right? Because we've closed it, but we've closed it with an outcome.
The unsubstantiated, Ann, are those typically consumer complaints?
I would say of the ones, like, I see quite a few unsubstantiated consumer complaints. Yeah. And then citation, it's 349, which is similar to the letters of admonishment. And then those that are referred to the AG's office, from the time that we receive it to the time that we refer it to the AG's office, the average right now for cases that fell into that status over the last 11 months was 340 days.
340 days.
From the time we receive it to the time that we close it and refer it to the AG's office.
And is it just coincidental that there's the letters of admonishment and citations are the same?
It's done in the same unit, so it's just kind of, they do them all at the same time, if that makes sense. So it's kind of the same process. So the widget count is different, but the time that it takes is about the same.
So just looking at the 3-year average, it looks like it's going up in terms of the average days compared to 15, 16, is that right? And 16, 17?
For the case closures, is that
For
what
the
you're
letter of
looking?
admonishment and citations, looks like it was like 282 and 15, 16, went up to 335, 319, and then now it's up to 349?
Yes.
It's taking longer?
For it from start to finish, yes. It could, it could be that the investigations, some of it is also, it's the point in time, it happened in the one fiscal year. So if we had a lot of cases that were closed the following fiscal year, it's going to be caught in the next one. Do you know what I'm saying?
Could some of these also be due to just the sterile compounding involves more
A
technique?
lot of them are, because we had to
Expertise.
redirect to do all of those inspections, absolutely.
And it involves more expertise to review those. Okay.
So one of the things that would be helpful from the staff level is to find out if this kind of information, this is far more detailed than you generally get in the inspections. Is this something that would be helpful for the committee to receive? And if so, have we hit the mark? Would you like different types of information? This is really trying to get to the understanding what the different cycle times are, so that we can then be measuring whether or not we're able to reduce those times to get to something closer to where you all would like us to be.
Well, I am getting kind of confused by presentation here. Something more graphic.
Maybe just going over what these are, like the measure received, is that the number of complaints received? The volume? So it's gone down over 3 years? Is that what that first column, the first line is received? So it's all the investigations.
So those are the ones that we've opened, yes.
Okay, so it's gone down. The cases closed without investigation with aging received to close, that's gone down too.
And that's the cases closed.
So without any kind of investigation, so we receive like a complaint about a rude pharmacist or something. Generally, we're not generally not going to open up
Low
an investigation
priority,
on
yeah.
that kind of thing. Well, it's
Everything's
not,
gone
we
down.
can't really do too much about.
Oh, okay.
Yeah, I mean, if we've gotten several of them, or some, it's not just a straight open and close. Sometimes we'll look at the license history and see if there's anything weird there, or those kinds of things. But there are some that you can tell based on what the initial allegation is, that it's not going to be jurisdictional pricing issues sometimes, those kinds of things.
Well, it might be helpful to do some of these things as percentages, because if your cases go down, then the other numbers are naturally going to go down, right? So
Right.
it may be better just to look at it as a percentage of total.
That, yeah. we
Yeah,
can
and
present it
do you
graphically.
like the 3-year? Do you want, as we're beginning to do this? Do you want, are
3
you?
year's good.
Okay, so we'll do 3, we can add in percentages. I don't know if the definitions mean a lot to you. We do have the desk and the field broken out. Our desk investigations are generally far more straightforward, which is why they are, so that you can kind of see that those move through a little bit differently. Hoping that that was helpful, but not really sure.
Sometimes, though, we have to wait for the convictions to come in. Sorry, we can't close it until we get, or do anything with it, with respect to a disposition until we get a conviction.
So one of the things I noticed under the first section, Anne, is the review time. The average dates from the date report submitted for review to date first or second level reviews completed went up dramatically from 1516, almost doubled, into 1670 and 1718. Do you see that?
Yeah.
Is there a reason why that went up so much?
Sometimes what we're given the opportunity to do is implement new programs at the same time that we're also trying to balance other priorities. So we try to keep the first and second level reviews going at the same time as we're also trying to balance some of the other priorities that are also going on. The first level reviews are generally done by the supervising inspectors, and the second level reviews are done by our 2 chief of enforcements, Jenny and myself. So depending on what's happening, we try to keep them moving as quickly as possible, because that's an easy way to shave off overall investigation time. But sometimes if there's other priorities, we're a little bit delayed.
But this would be good to monitor so that you can shift resources to try to look at what's going up so that you can balance it.
An example is because we've been working on a lot of other initiatives. What we did was we just blocked out a couple of days and we just really focused on the case on the first levels and the second level reviews, because sometimes when you have the dedicated time, it's easier to do that, and then it also creates a nice opportunity to do a lot of norming, because you're seeing a lot of it at the same time. That's where we identify, if there's some trends. Sometimes that's another way to get to them.
Now, with aging, the phrase there, why do you put that in? It seems like the sentence makes sense with or without that. Is with aging necessary there?
I think it was just trying to show that we're going to give you the time frame. I didn't do the labeling on them, but I think we're showing you that how the volume as well as how long it's taking.
Well, now, and one of the now putting this as, it'd be easier to see this in graphic representation, as Jenny said, but I wonder if a comparative, like 3 comparative timelines or something like that. You won't get a fiction because the number of days here is kind of what we're looking at. And anyway, we can discuss this before the next meeting.
If it works, we can play with a couple of things and work with the chair offline to try to make it a little bit more meaningful for you. It's intended to be meaningful.
Right.
So
right.
if we haven't hit the mark, it's always good to get the feedback so that we can really be giving you what you want.
Yeah, I think this will give us a handle on what the question, and so not that it deserves questioning, of course, but.
And just from a general high-level overview, what you look at is your volume has decreased, yet some of your times have gone up. So you have to question what caused that.
Right. So, but this is absolutely, but this is also just the picture related to investigation. It doesn't talk about the administrative cases, hearings, inspections, any of that stuff, right? This is just context specific to the investigation. So it is a little bit vacuuming in that respect, if that's even a word. But do you know what I'm saying? So it's providing part of the context, not the full.
Understood. Thank you. But good data. Thank you.
Oh, yes, definitely. Okay, well, because of the time constraints, let's go to number 10 here. Discussion and consideration of the board's enforcement statistics. Is there anything fascinating in that?
There's
Oh,
always,
oh my goodness sakes.
there's always fascinating stuff.
Okay.
I just had a question. I'm not sure one of these measures, one of the things that I hear, as some of you know, I'm the probation consultant to a number of pharmacies that went through the disciplinary process. And one of the things that I hear that surprises them is they will have an inspector come in. For example, there was one where the inspector came in April of 2012, and there was some issues, but they thought they took care of it. And 2.5 years later, they got the surprise letter from the Attorney General that was the accusation. Which measure on here is from the date of the inspection to the date that the letter comes from the Attorney General?
So we don't have from the date of the inspection, but we have the investigation time, right? So the trigger, the investigation could be triggered at the time of the inspection, or it could be that we went out because of something else and then identified other issues. But that right now, that would be, if you're looking for just that piece of it, we're averaging of those cases that were closed in 17, 18, 241 days, because it would be a field one, and you're looking at the investigation time frame.
I see. Okay.
Does that help?
Yes, thank you.
Okay, so in this particular case, the pharmacy thought they'd taken care of everything, and then they got a...
Yeah, they're frequently surprised. When
Apparently
they get
that
a letter.
happens a lot.
They're frequently
I've heard it.
surprised when they get the letter. And they haven't heard anything in a while. They don't even know there's an investigation going on. And you don't get any kind of warning. You get a letter from the Attorney General that, scares you pretty good.
So I would be curious to know that I'm curious to hear that they knew nothing, because generally we always issue a notice of violation that advises them that we have found things. So I'd be curious that they did not receive it in that case. So I'd be very interested to speak with you offline to find out who that one was, because I'd be curious where it broke down. Because generally, if it's something that's identified during the inspection, it's being identified. And then if it's something that we discover later, we're generally issuing some kind of a letter that's advising them, because we're asking them to respond and give us additional information as part of the investigative process.
How much time would generally lapse between the time that they're notified in some manner and the time that they get a letter from the AG's office?
So that was kind of what Estag Room was talking about in terms of the different steps. So for us, from start to finish, it's looking like for those that are referred to the AG's office is 340 days.
Okay.
So, but within that investigation time, we have generally issued some type of, if it's found as part of an inspection, it's included on the inspection report itself.
I think that's what she's talking about, because I've heard this from other pharmacists, that they actually heard something and then they didn't hear anything for quite a while and figured, well, it was already handled or something. And then, 2 years later or whatever it is, they get a notice that they have to appear,
Their best clue is to look at the inspection report in that case, but our field staff are not empowered to go in and give a citation and fine in the field.
Right.
That comes in and that's what takes part
Well,
of the
could
time,
we-
because it goes
could
through
we-
layers of review.
Maybe what we could do is, when they are notified that something was found, something can go out at the same time telling them that, it could be a year or two before you get another letter, but, this is an ongoing investigation or something like
Well,
that.
they've only identified something that was of interest to them during the inspection. They then have to go back and write an investigation report, which is then reviewed by a supervisor before any disposition of where that's going is known. So the inspector is actually, to a degree, because it's the quality of what you identify in that report that's obviously going to make the investigation, but is really separated from the outcome that's going to result from what he or she found in the field and the investigation he or she conducts.
But isn't there some way we can let them know that this isn't over and that they're going to hear something down the road?
It could be over, because the report could go in and there could be no action taken on it too. So I don't know how we would tell them that.
I don't know, but it seems to be a problem.
Satinder Sandhu with Walgreens. I think where the confusion is that when the inspector comes in and on the inspection report, they'll write a correction or it's a citation. So the
Violation.
the violation. So sometimes the pharmacists don't completely understand what that all involves. So, and then afterward, the pharmacist gets hey, send me this information or that information, because like she said, it starts the part of the investigation. They think that they provided that information and everything is taken care of. That's where the misunderstanding comes in. But I think it would be, and also usually, depending on inspector's behavior, if they're really cordial and they're being friendly, the pharmacist thinks that everything was okay. Yeah, they found this, but I provided this information, it's all right. But after the fact, when they're surprised because they didn't realize there was anything wrong.
Right.
I think it'd be helpful, I think inspector make that clear while they're there that, hey, this is not the end of it. There's going to be more, you'll get something later on. I think that probably all it needs to clarify it. But right now, I think that's where sometimes the pharmacists are confused.
Sometimes we just simply won't know at the time that inspector leaves, though, or the inspector wouldn't know what the outcome of that inspection is going to become.
That's true. Like in a lot of the cases, they may say that it's a violation, but later on, the information they requested, it was not a violation, so it just gets dismissed. But I think that is where the confusion comes in, because sometimes nothing happens, and other times ends up being
Yeah,
well, I think they could be told that it is possible
Yes.
that down the road, you're going to be receiving a letter from the AG or whatever, and there's going to be a hearing or whatever. But just let them know that it's a possibility that it's not over.
Yeah, you're absolutely right.
Thank you.
Okay, so on to number 10.
Yeah, I think we're on 10.
Discussion and consideration of the board's enforcement statistics. Jenny,
What do you want
Ann?
to know?
anything to report here?
So, we agendize this slightly differently than we normally do. Normally, we just provide you and say,
Right.
here are the stats. But what we were kind of hoping we would get from the committee this time is this helpful information? Are you looking for different kinds of things? So this is really talking a little bit about like our workflow, how it's broken down by the different teams, and then what the outcomes have been. And is this really kind of what you're looking for? Or is there data that would be more meaningful for you to consider? You've seen this many times.
Right.
And then at the end of each fiscal year, we'll give you like 3-year fiscal year comparisons. But what we're not, I don't think that we've ever checked in with the committee and the board to make sure that this is actually helpful data. I mean, we'll probably still be using it because we use it for, our widget counts and things like that. But is this what's meaningful and helpful to you, or is there something that we should be replacing
I think it's
this with?
meaningful and helpful.
So we talked earlier when we talked about the goals, if we could look at whether any of the goals have measures that we can add to this. And then the other thing I think would be helpful on some of this is just timing. How old are the cases? What's the oldest case? Do we have any idea of that?
So under the pending, we
Yeah.
could put down the date range or something?
Yeah.
Okay, add in the date
How
range?
backlogged are we?
Okay, yeah. Well,
terms of-
is it okay, we'll just give a range?
Yeah.
Okay, so, all right, perfect.
And then just look at the goals and see if there's anything else in there that we could measure.
But based on what Josh told us earlier, it doesn't look like we have really any control over the length of time that these take.
But we do on the complaints. I mean, we do on what happens in the board, right, before it hits Josh.
Yeah, I think, so we break it down by team type right now, so we could put down what the average aging dates are for the respective teams. So you could see by team kind of what the average investigation time is. So we'll do it with the investigation time. You know how we had broken down the different segments because these are pending? We'll do the investigation time, if
Okay,
Okay?
that's fair.
Because that's pre when it gets to
Yeah,
Josh,
exactly.
right?
I understand.
I like how all these cases are now my cases individually.
That's what you get when you do this presentation, Josh.
We know that once it gets to him,
Prefer
it's
that,
gone.
Josh. We prefer that.
And I don't want the takeaway to be that my office is not constantly working to improve timelines. I don't mean to say that like the data is static and it won't ever improve. I just don't want to be unrealistic in terms of expectations.
That's okay, you're good at PR.
Count what's important, Josh, and
Lower our expectations,
the way
is
to
that
do
what
is to monitor it. You got to monitor
Yeah.
it.
So do we have on the workload statistics the cite and fines? Is it, maybe I'm just not finding it on here.
So on the first page, under its letters of admonishment /
Oh, there it is.
citations and fines.
Got it, okay.
Where are you?
Right here, at the very bottom.
Oh, okay.
First page.
I got it. Got it.
We had less in April through June.
Not over
Not a
yet.
full.
Well, yeah. This is data for the first 10 months of the year.
So May, June looks like it'll be about the same, yeah.
One of the things that we might want to consider adding in based on the discussion at the last board meeting is on the citations issued, how about if we break out proof of abatements? So we'll indicate those where we've added in the proof of abatement that gets to the education piece. So we'll add that in as
Great
I'm
idea.
thinking, is that okay?
Yep, great idea.
Okay. That it for that? Okay. You don't have anything to move on that, right? All right, number 5, discussion and consideration of potential
Getting through this.
statutory regulatory amendments to allow a reverse distributor to accept medications for destruction in limited circumstances from a previously licensed
I'm
source.
sorry, Alan, I just have one question on the cease and desist on the workload statistics. When we see immediate public protection sanctions, I see cease and desist for sterile compounding, but I don't see a normal cease and desist.
We have to add that.
You
I
have to
caught
add
that
that.
this morning
Yeah,
also,
yeah.
the
'Cause
unlicensed
I remember
activity
hearing
one's
one, and
not
I'm
on
thinking,
there.
I
Yeah.
didn't see it on here.
No, we did,
Okay.
we definitely did one.
Okay, sorry, Alan.
All right, okay. Under current law, reverse distributor is prohibited from acquiring dangerous drugs and devices from an entity unless it's licensed. This creates a barrier to the removal and destruction of such products when a pharmacy, wholesaler, or other licensee is surrendered or revoked. The board staff is requesting that the committee consider pursuing a change in the law that would create limit exception to allow for a reverse distributor to remove and arrange for the destruction of drug products for a limited period of time after a license is canceled, surrendered, or terminated. Should the committee and the board agree, the staff will work with the council to develop language.
Second.
Any public discussion on that? All right.
Deal to us.
All in favor? Unanimous. What a committee.
Good job.
All right. So, with that,
We have one more we skipped before?
I think that's it.
You did it? Okay.
Yeah.
Ann, have you been, I thought it was it.
Okay. And then the last thing is the next meetings.
Oh, we're gonna have some more, right? We're gonna schedule some more?
Right now, we have two scheduled, one for September and one for December.
And then we passed out the ones
For
for
2019.
2019. And then I heard earlier today that the thought is that we need to add some additional ones.
Right.
I think so. Oh, somebody's sneaking up here. Public comment?
Public question.
Unless I looked at my calendar wrong, I believe September 8th, the next date, is a weekend.
Nothing stops us. We'll meet anytime.
Awesome, I'll see you then.
Might make it easier for some.
Really?
In some cases, for some of us, it might be.
Good catch,
Calendar
Marie.
says.
Oh, Saturday, yeah.
Okay, we believe you, Marie.
Is that actually supposed to be the 5th?
Is that?
I think it's supposed to be September 5.
Yeah, it's on my calendar for
It's
the
the 5th?
5th. Yeah.
Okay.
Okay, so we have 2, September 5, and December 13th, then we may think about having another one
One more
here.
somewhere in there.
Okay, is that it? Anything else? All right. Meeting's adjourned.
Nice job.
Good job, Chairperson Shaw.
Feeling